Boom. All right. How's everyone doing? And I'm not late. Your clock is fast. Oh, it's been a day. It's been a week. I know it's only Monday, but how is everyone? How's everyone feeling? Hopefully, people are doing all right. Hopefully, people are having a what is it? Having a good time there. Um, so yeah. Ah, it's there's a whole lot that's been going on. I don't know if we've got I don't know if we've got time to cover everything, but we will try to get through as much as we can. Things are a little crazy in the world. Um so I hope everyone's having a everyone's having a great day overall. Let's sort of start things off with some, I guess, lighter fare. We don't want to wade into the heavy stuff of the world right away, so we'll wander in nice and slow with some effery, which I can't really, I can't go with all the cursey words yet. We're not at that time, but let's um, let's have a look at what we're looking at here. So, uh, I just want to note this as a starting point. So the case is Manulife Bank of Canada and Shelley Thomas, plaintiff defendant. And then we get to this third thing. Peter Temple, interfering third party. I've never seen this before in my life. I have never actually seen plaintiff defendant and interfering third party. So that is that's crazy. I can't really express how nuts that is as a starting point, right? How absolutely wild it is that they're calling somebody interfering third party. I'm actually now just gonna stop. I'm gonna do a really quick internet search here for the phrase interfering third party in Canley. Oh, it does appear on another similar case. So, all of these are probably going to be wild. I got to go through all of these later. I am so thrilled. I just found a whole new level of bizarre. So yes, we've got interfering third party is now the list of the day. So, what's happening in this case? So, on January 9th, Manulife Bank of Canada filed a statement of claim seeking foreclosure of a property owned by Shelley M. Thomas, Ms. Thomas, and judgment to collect an unpaid credit card debt foreclosure action. This memorandum of decision responds to two issues. So, what's happened is she's not paying her mortgage and she's not paying her credit card bills. And there's a couple of reasons why that happens. The first reason is that somebody might have fallen on hard financial times. And this happens all the time, unfortunately, and all the more so in the current era because right now the economy sucks and it's hitting a lot of people in the face. And that is awful. That is just miserable. And I'll just say there's a bunch of people who have unsubscribed to my Patreon saying financial circumstances have changed. And I just want to say that's fantastic because if you are experiencing financial hardship, this is a luxury thing, right? Supporting me is a luxury good as opposed to a need. And so I never want to hear anybody say, hey, my kids are going hungry, but I'm paying for you, or hey, I can't meet my mortgage, but I'm still keeping, this subscription going. I know it's not a lot, but priorities. So I am never upset when I see somebody saying, hey, my financial experience has changed, because people making good decisions is a good thing. So this memorandum of decision responds to two issues. So first, the emergence of organized pseudo-legal commercial arguments from Meads and Meads. And so what does this mean? Well, this means sov citizen BS. Sov citizen craziness. And that an interfering unauthorized third party, Peter Temple, Mr. Temple, has introduced himself into this litigation, and worse, is at a minimum arguing and advancing OPCA concepts that can only have negative effects on the operation of this court and the interests of both involved parties. What does that mean? This guy is probably one of these people who tries to be like a sov-sit lawyer. And if you have one of these people in your life trying to help you, I can tell you this is like somebody trying to help you navigate like your boat by chainsawing holes in the bottom, because these guys are a disaster for everyone who has anything to do with them. So, yeah. So they continue on. I am the administrative justice of the Court of King's Bench of Alberta who responds to abusive litigation and litigants. What does this mean? It means that there is a justice who is essentially the go-to person for all of these crazies. And so once you get onto this crazy track, you're going to end up with one of these justices. And how do you get to be this justice? Like, you're already a justice of the Court of King's Bench. How do you get to be the person who responds to these? Well, you get to be this by being the cantankerous, the most cantankerous, grumpy person who is not going to put up with any BS. This is the end of the line. This is, you have run out of patience, and now you have been referred to the angry justice. So now the angry justice is going to be polite about it, but they are the angry justice. This matter was referred to me by Justice Fraser after Fraser heard and rejected an appeal of decisions of the application judges of the Court of King's Bench of Alberta. So basically, Justice Fraser went, this one needs to go into the crazies pile, and it did. Subsequently, this court received a large volume of abusive OPCA documents that targeted court clerks and judicial decision makers. These guys engage in sort of paper warfare. And what they'll do is they'll start filing court applications or sending sort of weird threats to all sorts of people that are involved in the file. And that often includes like court staff who just have to do things like, hey, I can't file this because it's crazy. And because there's an order on your file that I not file this because you file crazy things. So, all OPCA schemes and concepts are categorically rejected by Canadian and other international courts, and anyone who employs those concepts is an abusive litigant, says the court. Mr. Temple prefers straw man theory, which is one of the many flavors of this. Maybe at some point I should do a live stream just going through Meads and Meads. It would be a long live stream, but I think people might enjoy it because Meads and Meads is one long roller coaster smackdown of the whole OPCA world. So they say this is a form of pseudo law that is so notoriously false that anyone who employs straw man theory is presumed to do so in bad faith and for abusive ulterior purposes. Now, how do people get wedged in on this? How do people get bogged down into straw man theory? Well, in part, what often happens is that they're desperate. You get people who are losing their house. You get people who are losing their kids. You get people who are facing criminal charges, and they are panicked because everyone they go to, either one tells them, I can't help you because it's expensive. Like, lawyers do cost money, and that's sad. I would love to be doing this pro bono just to try to take a tiny bit off that weight, but there's a lot of people out there who need legal help who can't afford it. And so somebody else who is somebody who says, I'll help you, starts seeming pretty good. But the other thing is that these guys make promises in a way that lawyers can't and won't. And what I'll say is, like, I'll get people who come into my office and they say, hey, I really, really need you to get me, get me acquitted of this criminal charge. And I'll look at it and I'll say, well, the bad news is they've got really, really good evidence. Like, they've got you on video doing the crime. They've got multiple eyewitnesses to you doing the crime. They've got that 3-hour interview you did with the police where you told them, yes, I am the person and I did the crime. Those things are all really good evidence, as well as, like, hey, here's your DNA, all of this, right? There's all the evidence against this person. And they're not going to be happy, especially if it's a big, serious crime. Like, hey, you're going to jail for 2 years. That's what I can do for you. Crown's asking for 5, but I think I can get you 2. People don't want to hear that the best you can do for them is 2 years in jail, even if that's actually some great work. Like, even if that is fantastic. I got fired by a guy after I got him a deal from 5 years down to 2 years. He didn't go sob sit. He went with another lawyer, and I can tell you that other lawyer got him 4 years. So, just saying. The Crown was like, that deal is a deal with you. I'm not holding it to that other lawyer who I hate. So, I don't know if that's the best, but yeah. But the thing is you get people who are like, I owe all this money to the bank. And the lawyer says, well, we might be able to keep the bank from taking your house so long as you can get on to payments again right away. But that might not even be the best thing. You might want to consider walking away from the house. Meanwhile, this other sovsit says, you know what? Not only should you get the house and not have to pay any money, but the government owes you money. Doesn't that sound really tempting? And almost all fraudsters and scams and so forth are based on that promise of something you really, really want. So that's how people get bogged down in this. And I've got some sympathy for them. But you got to learn, like, you got to go into court and just read the room that this is not working. And I hope Ms. Thomas reads the room and knows that this is not working for her. So this timeline summarizes the foreclosure action to date. January 9th, statement of claim filed. February 21st, she's noted in default. So that probably means she didn't defend the, she didn't defend it. She just let it, she just ignored it. And so when that happens, the court can basically determine that you have lost the case based on your failure to defend it. If you get something that says you're being sued, take that seriously. Like, once you get official court paperwork that says you are being sued, take that seriously, because it starts triggering some deadlines that are real and incredibly nasty if you skip them. So, yeah. All right. So counsel for Manulife applies for a redemption order over the foreclosed personal residence. The supporting February 9th or February 24th affidavit of Kathy Strauss deposes that the unpaid mortgage debt is $262,727.63, which is more than the appraised value of the foreclosed property. What does that mean? It means that they want to keep the house and give her no money, right? We want the house. We want you to have no money. She's also noted in default in relation to the credit card debt. So Judge Schlosser grants the redemption order sought by Manulife. What does that mean? March 29th, Manulife owns the house. Manulife gets to take the house. May 3rd, Manulife received and accepted a $230,000 offer for the foreclosed residence. So Manulife sells the place for 230 grand. And then at this point, Ms. Thomas and Mr. Temple appear for the first time in the foreclosure action after they've already lost. After they've already lost this, they show up. So the foreclosure action is adjourned to June 14th, 2023. And then May 25th, things start to get squirrely. Not the good kind of squirrel, but like squirrely. Mr. Temple submitted a judicial complaint against application Judge Summers that was incorrectly addressed and mailed to Chief Justice Redmond of the Alberta Court of Justice. That correspondence was then redirected to Chief Justice Moreau of the Court of King's Bench of Alberta on June 8, 2023. This correspondence was rejected by letter on July 5th, 2023, because Mr. Temple was not a party to the foreclosure action. I.e., dear random noob, like random weirdo, you are not part of this litigation. You do not get to file things on this litigation. So, you're just completely SOL on that. So go away is basically the letter that they proceed with. So, Ms. Thomas and Mr. Temple appeared before applications Judge Smart, claiming no sale should occur because they've located a private investor and demand documentation in relation to the debt. Judge Smart says the sale for $230,000 shall proceed and that she's got to vacate the property by July 14th, 2023. Ms. Thomas files a civil notice of appeal. So she's appealing this, and then it was subsequently unfiled as premature and outside the jurisdiction of the Court of Appeal of Alberta, i.e., they file this and the court says, no, out it goes. Ms. Thomas filed an appeal of the May 3rd, 2023 decisions of the application judge, and Justice Fraser heard and dismissed that appeal. And then July 13th, extensive and largely duplicate pseudo-law packages addressed to the applications judge involved in the foreclosure action, to Court of King's Bench of Alberta clerks, and Chief Justice Moreau were received by the court via registered mail. These materials are discussed in more detail below. So, let's look. Is this the appendix? So this is one of the documents that they apparently sent in. So let's just have a look at what crazy SovSit documents look like, or at least one of them. Now, when I say what they look like, they come in all sorts of forms. One thing that is popular with sovereign citizens is they will put a blood or red ink thumbprint or fingerprint on something as a signature. If it's in blood, that's especially creepy and ends up with your filing getting like marked as like a biohazard. So don't do that. I am a lawyer and I can tell you, I do not bleed for my clients. Like, that is not a service that real lawyers offer. So I am Shelley Marlene Thomas, a sovereign woman in the Kingdom of Canada, registered as such in the International Court of Common Law in the United Kingdom. I bring you the following. Now, I'm just going to say, Canada and the United Kingdom, our court systems are now separate. I say now because that was not always the case. But there is nothing that you can file in the United Kingdom that is a court document here. Unless it's like a mortgage in the United Kingdom that you want to enforce here for some crazy reason or whatever. But like, yeah. I bring the or like a marriage in the United Kingdom. I bring the following to your immediate attention and order you to cease and desist all fraudulent activities relating to any attempts of theft of the property and they list the address, which she's not in anymore, owned by Shelley Marlene Thomas. At least I don't think she's in there, but it's published in a court document. So there we go. I claim sui juris. I do not understand you. Now, understand is one of these loaded languages or loaded words for SovSits. And I've had to like disentangle what sort of crazy things they mean. So sometimes some sovereign citizens will say to understand somebody means to stand under them. And so they'll get really particular when the court says something like, do you understand what I'm saying? Which means like, do you comprehend words? And the reason why the court often has to ask this of sovereign citizens is that they will be, this person comes into court and starts babbling a bunch of gibberish. And the court is like, if you keep doing this, I will send you to jail. Do you understand? And they're like, I do not stand under you. And it's like, okay, there you go. I do not have an international treaty with you. The statement of claim is not directed to me, but to a corporate legal fiction representation of my name. I have no affiliation nor knowledge of that corporate entity. This is the straw man theory, right? They're not coming after me. And so the way straw man theory typically sort of works is basically that everything good that is happening to me is owed to me personally. But all of my debts and obligations and anything I don't want to do, any of those things, that belongs to this fictional thing that I can disavow. It makes no sense whatsoever, right? It's just like, this is not how the world works. There's just you. As such, you are guilty of fraud based upon the definition in Black's Law Dictionary. And I can tell you, Black's Law Dictionary is just a dictionary. And when I say just a dictionary, like, the court can look at dictionaries on occasion if they need to understand a word, but it's not like binding law. I can't tell the court, hey, you are, you're reading, you're in violation of Black's Law Dictionary. Yeah, so they quote the definition of fraud and misrepresentation, which at least these seem like they could be from Black's Law Dictionary. Sometimes they make up definitions and say they're from Black's Law Dictionary. So you appear to have committed this fraudulent act with intent. So the letter from Witten LLP was addressed to Shelley M. Thomas, a living woman, obviously a deception to include a notice addressed to a legal fiction corporate name that bears no relationship to the original addressee. And the letter from Witten LLP was signed by either another corporation or a dead person, Andrea M. Steen. We are confused by this apparent attempt at deception, and as a result, this cease and desist order is directed to both corporate bodies. Yeah. The dead person thing is also sometimes a sovereign citizen thing where they basically say, like, if you go before the court, then you are legally dead. It's crazy. You are also acting under martial law and may face extreme punishment for infractions against the civilian populace. Acts of plunder, mortal violence, and mischaracterization of civilians as combatants are all death penalty offenses. What? Mischaracterization of civilians as combatants. Sir, this is a Wendy's. Like, what? Okay. When you address birthright citizens of the Kingdom of Canada and deliberately confuse living people with corporate franchises you have named after them, you commit barratry and personage. This results in press ganging land assets into international jurisdiction of the sea, a crime outlined worldwide for 200 years. It is a recognized act of inland piracy, and it carries the death penalty. Inland piracy. What? I mean, there have been river pirates before. That can be a thing. But also, press ganging is a thing that used to happen and might still happen in some countries in some places, but it doesn't happen really anymore. What press ganging is, let's say you got a ship and you need 60 sailors and you have 40 sailors. Well, you just go round up some drunks and they wake up in the morning on a boat. And at that point, it is really difficult for them to leave. And congratulations, you're a sailor. Where are we going? India for spices or wherever the hell. this doesn't really happen nowadays. Nowadays, it's more like, people, they put out an application going, hey, we could use 60 sailors, and they get 9,000 applicants. This is not how we don't press gang anybody anymore because people just voluntarily apply for the job. So, cease and desist immediately. Immediately aiding and abetting the theft of property, sending correspondence that misrepresents my God-given name. I'm just going to say God probably didn't personally show up to name you. Yep. Any contact with Shelley M. Thomas through unsigned documents or attempts to confuse, whether it be through mail, in person, telephone, email, or other electronic means, at the very least, you will be charged immediately with harassment and may warrant military involvement. Now, I'm just going to say, lady, you can't pay your mortgage. You can't pay your credit card bills. Where are you going to hire an army? Because I'm going to bet you don't have an army. I'm also going to bet you don't have a Hulk. And so you got nothing. Like, you've got this letter. That's all you've got. Don't threaten an army when you don't have an army. So, seeking remedy, we'll be filing a notice of fraud with the province of Alberta, the Attorney General of the province, along with the Premier and various levels of law enforcement. That's going to go real well. Real well. Due to martial law having been exacted, this case is being brought to the attention of the U.S. military and allied forces. Okay, you know what the U.S. military's thoughts on this are going to be? They're going to be like, hey, we need the special crazy person trash for this one. Mass arrests are currently in progress across Canada and the United States to end the corruption evident through the courts, medical, financial, and political systems. I'm just going to say no one's getting arrested. Because if they were, I'm making fun of them. And I suspect that they would arrest me. I have not been arrested. If you do not immediately comply with the cease and desist order, I will seek remedy through the Canadian common law courts. Where do you think you are, lady? Oh, she means a different court, probably run by her, her pet kangaroo here. So this will serve as your lawful notice to cease and desist all further actions described above, effective immediately. Govern yourselves accordingly. So she's learned at least one lawyerly phrase. Now, guys, govern yourselves accordingly is a phrase lawyers kind of came upon because lawyers are required to be polite and civil in our communications. So if I am sending a cease and desist letter, like a real cease and desist letter, to somebody, like, hey, let's say my neighbor, or let's say, let's say the CBC decides to start running Runkle of the Bailey as a TV show, and they just steal my videos and put them up there without sending me any money, right? And I want them to stop. I might send them a cease and desist letter. Although, quite frankly, if it was the CBC, I'd probably just jump to suing them. But, the cease and desist letter, you might end it off with, with govern yourselves accordingly, because what you can't say is, or else, douchebag, right? That's what that means, is like, effing do it. So it's kind of the respectful version of saying, F you. And yeah, that is just what that is. So, it doesn't really work against lawyers though, because lawyers kind of think it's funny. We all know that one's kind of a joke, but, yeah. All right, let's go back up to Peter Temple. So a first issue is that Mr. Temple has been illegally conducting the practice of law. Sort of. He's been conducting the practice of crazy while claiming he's conducting the practice of law. All right. And I've just got root beer right now. We're not going with anything stronger for at least a little bit, because if I'm going to do a drinking game on this, I will be... I will get so sauced. So we're not playing any drinking games with sob sits because that's yeah. So a transcript of the hearing shows Ms. Thomas initially interacted with the applications judge, but then an unidentified person who appears to be Mr. Temple essentially took over, advancing abusive pseudo-legal arguments and claims and demanding an invoice to establish the outstanding debt. I note at this point that Manulife had filed several affidavits, established the mortgage contract and debts, and judgment had issued on these conclusions. In short, this court had thus already confirmed Ms. Thomas's legal liability and quantum of debts. Attempting to re-argue these points was a collateral attack on prior unappealed court decisions. What is a collateral attack? Well, the courts basically want you to, if you don't like an order, they want you to challenge that order on its own merits. So, let's say somebody gets a court order that says, that I am not allowed to go, I don't know, go to the town of Spuzzum. We'll just pick something weird. Spuzzum is an actual town, by the way. Quite nice. But let's say I get a court order that bans me from Spuzzum. Well, if I want to address this, like, I have to go and appeal that decision. I can't go and just bring some new action to attack it. That's not. Instead, you have to do it the right way. So that's what they're complaining about there. So, applications judge granted an adjournment so that Ms. Thomas could provide a full redemption payment of the mortgage debt funds from a private investor. It was that Mr. Temple who then strenuously argued that more time would be required on the basis of vague claims of business and travel activities. Ms. Thomas did not in any way directly participate in the latter half of this hearing. Functionally, he was acting as her in-court representative. Now, the court should not have put up with this, right? The court should have been like, who are you? Okay, are you a lawyer? No. Sheriff, can you have that person removed? Because that's not how this goes. Just straight up, that this is not how things go. Now, the court was basically saying, oh, you've got a private person who will come in and pay all the money? Okay, in that case, we're willing to hold off on the foreclosure, right? And this sometimes happens. Like, hey, I owe $300,000 on my mortgage, but I won the lottery, and so I'm just gonna, pay it. That is a great thing when it can happen. So June 14th, he shows up and he identifies himself as Peter from the family Temple, rejecting that he's Peter Temple. And Ms. Thomas self-identifies as Shelley from the family Thomas. And Ms. Temple is asked to speak, and instead this exchange follows. So we're going to get some classic soft citizenry here. All right. Mr. Temple, I am making a special limited appearance representing the defendant, who appears to be the birth certificate of Shelley. Application Judge Smart. Uh-huh. Are you a lawyer? No, I'm not. Okay, you realize that would be an offense under the Legal Profession Act. Like, hey, that's going to be a crime, right? Mr. Temple, an offense? Application Judge Smart. Under the Legal Profession Act. Well, I'm not part of the legal profession. Judge Smart. That's right. That's why you cannot speak. Ms. Thomas, what have you got to say? This is Judge Smart, who, by the way, I quite like Judge Smart. He lives up to his name. It's like he's just not having it. Mr. Temple then repeatedly interrupts his application. Judge Smart attempts to obtain submissions from Ms. Thomas. Mr. Temple continues to be the only one who responds to applications Judge Smart, despite being cautioned that his doing so is prohibited and illegal. He's criming right now. Mr. Temple, and I gotta say, one of the worst places to commit a crime is court. Because it's such a bad place. There's so many reasons why it is the worst possible place to commit a crime. Do not crime in court. There are all sorts of witnesses who will be taken to be credible. because when one of the witnesses against you is like Judge Bob, that is, that's not where you want to be, right? So, no drug deals, no assaults, no attempted murders in court. We had one of those here in Canada. Don't do that. Mr. Temple repeatedly demands an invoice threatening a counterclaim and appeal. And yeah, when the applications judge attempts to explain the steps forward, Mr. Temple replies that it's not sufficient to me and it's not sufficient to Shelley. So he's the only one who talks, and then he is explicit in making a judicial complaint. He signs the judicial complaint in this manner. Sincerely, Peter Temple. Now note, he just said that he was not Peter Temple, but now he's Peter Temple. So he can't even keep his own BS straight for even a limited time. Yeah. So television producer. Now I'm just wondering, I'm just trying to find can I find Peter Temple, the, this guy? Like, what is he actually up to? Because I am super curious as to what this guy is about. I might do a whole stream mocking this guy if I can track down his stuff. Because television producer, ooh, that is that's interesting. We'll have to see about that. In this document, Mr. Temple is also explicit that he's not a lawyer. I've been a businessman running multiple businesses over 44 years. I spent 3 years as a professional trainer across Canada and the northern United States, training executives in the proper use of grammar. Okay, that's interesting. That I just okay. Moving on. That's got me a little stammered for a bit, but let's move on. So now they're going to get to OPCA concepts and arguments. So, straw man theory is a false belief that individuals have two linked halves or parts. One is a physical flesh and blood human. The other half is an incorporeal doppelganger, commonly called the straw man or a legal person. Pseudo-law litigants and promoters claim that governments, courts, and Canadian law have no application to the flesh and blood human, but only to the straw man. People are purportedly not born with a straw man, but rather the straw man is attached to humans via birth documentation, which is a contract. It is not a contract, by the way. It is not a contract at all. Then contractual authority chains through the straw man to the human. You get people now who try to like have kids and keep them from getting a birth certificate so that because they believe this crap, and all that does is it F's them up later on in life when they want to like apply for documents like going to school or university or getting a job. All of these things we really want a birth certificate for. Yeah. So there's obvious indications that they're engaged in straw man theory. First, referring to themselves with an atypical name structure. These weird names are basically like almost guaranteed that you're dealing with some sort of crazy soft citizen. Peter from the family Temple and Shelley from the family Thomas, which are human names, in contrast to Shelley Thomas, who is a legal fiction and a birth certificate. Yeah. That Ms. Thomas is not the defendant, instead that it is her birth certificate. Ms. Thomas is appearing in court as the representative of her birth certificate, which is weird. Like, nobody is suing your birth certificate. Yeah. All right. Ms. Thomas makes the false claim that two legal systems are in play, and she is subject to a different common law. Now, what common law actually is in the legal sense is that if, we have law that doesn't come about through statute and doesn't come about through, like legislation, but is the result of court cases. Essentially, it's judge-made law over time. And so that's what common law means, right? Just that we have precedent, we have all sorts of things. And nope, they want to imagine it's something completely different. And they say that they draw the distinction between common law and admiralty maritime law. Now, I'm just going to say, if you are living in Alberta and if you own a map, you should be able to tell that maritime law does not apply to anything you do, pretty much, because maritime law is just not a thing, right? So, yeah. She rejects the authority of Manulife because that is a legal fiction entity that can only have authority via contract. Now, Manulife is a corporation, and a corporation can be like a person. So, and I see people are identifying that they think that, they think it's this guy, which is the same guy I thought it was. But yeah, I'll have to do a stream going through his crazy crap at some point. So, yeah, he is, he's a weird guy. All right. So skipping on a little bit here. So basically they're saying that this is all in bad faith. They claim that contracts must have a wet ink signature so that all electronic form contracts are not legal and binding, but are instead fraud. I can just say signatures in, at least Alberta's got legislation on what counts as a signature. And that can be almost anything. In fact, signing your name at the bottom of an email. Oh, hey, MLS. Good to have you here. Signing your name at the bottom of an email can be sufficient to be a signature. Electronic signatures are allowable. Yeah, and did she not sign a mortgage agreement? She did. She's just saying that because she didn't sign it in wet ink, that it's not valid. Now, note, there's a thing about when a signature, or if a deal like this is not valid, it isn't that you just get to keep the money, right? Like, let's say you have a contract. Let's say I have a contract with, Vez from Quebec, and I agree that I am going to sell her a car for, $80,000. And so we make this agreement. She sends me the $80,000. And then I say, no, I don't want to sell you the car. And I'm not going to sell you the car because it turns out that the contract has a problem with it. This contract is void. And the court looks at it and says, you know what? We agree this contract is void. What they're not going to say, I mean, they might say you don't have to give the car, but what they are definitely going to say is you also don't get to keep the $80,000. They will make you return that. They're going to so this is why whenever you're suing somebody in contract, you also sue under what's called unjust enrichment, which is that I gave you or Vez saying I gave you $80,000 and we didn't have a contract. We didn't have any reason for you to get that $80,000. I want my money back. And she'd get it. She'd get it. So even if the signature is not valid, she would still have to pay the money. This is the problem. They might not. Yeah. All right. So some comment here is warranted about the UK Sestui Act, but it is UK legislation and therefore doesn't apply here, says the court. Now, this is where things get additionally fun. Ms. Thomas's materials also indicate the influence of Romana Digilo, the purported Queen of Canada. Queen Digilo supposedly became head of Canada, displacing all existing government and royal authorities when Queen Digilo was granted that title by King Carlson of the United States as a reward for Queen Digilo repelling a subterranean invasion of North America by the communist Chinese military. Yeah. All right. That's just I can tell you Romana Digilo is herself a completely bizarre figure. She claims to be a lizard person. She claims to have all sorts of healing properties. She is weird. And so now she's showing up in this as well. We're hitting all the weirdo buttons here. For example, Ms. Thomas makes reference to the Kingdom of Canada, and she includes a promissory note that purports to promise payments in Canada guaranteed by the Kingdom of Canada for Canadians and Royal Decree number 38. The Royal Decrees are also Romana, like Queen Digilo, and I say queen in the most mocking sense I possibly can. So, yeah, I can tell you, Ms. Queen, whatever, Romana Digilo is currently sending all of these things about how she has like voided your mortgage. She has voided your, your tax payments, your utilities bills. And so people, as a result, who believe in her BS, stop paying their mortgage and they stop paying their, and you would be shocked at just how fast your bills will add up when you stop paying them. Real fast. As a note, if you are early on in your mortgage, it might be that you're paying like 75% of your payment to interest and 25% to principal. But if you're missing payments, that's 100% of your missed payments going directly to the principal.
The interest. Because the principal won't change. The interest will just keep growing.
Yeah, so you end up ratcheting yourself into a much worse situation.
Yeah. Compound interest is a biatch.
Yep. And this is another person who has followed Romana Digilo directly into losing their house. Romana Digilo has left this giant trail of people who are like, they're coming to seize my house. They're shutting off my electricity. They're doing this. They're doing that. Save me. And she's always like, nah. So.
Yeah.
So we are, we're just kind of going over some crazy here. So Peter Temple is showing up in a bunch of different cases now, it appears. But they note that he is not a suitable court representative. And so they make the following court orders, which are going to be violated in short order, I'm sure. But
this means the Queen of Canada is seeking new legal representation, and don't I have just the Canadian lawyer for the job?
Oh God, no. The Law Society has actually noted that it's unethical to sign on to these kinds of things, and where that gets
I can't imagine why.
It's unethical to even notarize these things, like because they'll sometimes come in. They're like, "I want this notarized," and you're like, "I'm not doing that." Even though notarizing normally is just like, "Yes, this is a real copy of something else," because people want like a notarized copy of their passport all the time, and all that is just I'm like, I'm a lawyer. I confirm that this is a real copy of the real passport. That's all that notarization means. And so, but you get lawyers who are notarizing these things saying, yes, this is a real copy of this other one you brought in.
Mm-hmm.
And then they would claim that notarization had all sorts of powers. And So the Law Society basically said, no, you're not allowed to notarize these things.
Confusing the concept of notary with its Mexican and other countries equivalent, where that position does have a lot more authority.
I don't even think that they're necessarily confusing so much as just making stuff up.
Okay, I was just trying to be generous. In
That's fair.
Mexican law, the position of notary public, I don't understand it very well, but I understand that they have a lot more authority than its
I've
American and apparently Canadian equivalents.
I've heard the same, and I see somebody saying
Yeah.
a notary has to be an attorney in Canada. No, a notary is like you can become just a notary, but all lawyers, by virtue of being lawyers, are also
Oh.
inherently notaries.
See, we don't get that one in the United States. You have to apply for that one separately.
I'm also inherently a commissioner of oaths.
Ooh.
But you have to buy the stamp yourself.
Will you administer my oath to the one true Queen of Canada?
I will not. Also, I would not want to do that. So he's prohibited from providing legal advice, preparing documents intended to be filed in court for any person other than himself, and filing or otherwise communicating with the Court of King's Bench of Alberta, except on his own behalf, and acting as an agent, next friend, Mackenzie friend, from Mackenzie and Mackenzie, and Alberta Rules of Court. Mackenzie friend basically means that when you are self-representing, you may be able to have another person there to do certain tasks. Like, for instance, organizing your binders, or taking notes for you, handing you exhibits. Like, all of these things are non-lawyer tasks that you can theoretically have somebody next to you to do.
Like a paralegal, maybe.
I mean, this is not even like a paralegal. This is just like kind of a helper monkey is essentially what it is. It's somebody who's like, hey, I need you to take notes. I need you to, but they can't do any of those other things. Sov sits and other crazy weirdos love to try to get in via the Mackenzie friend aspect. They're like, I'm just here as a Mackenzie friend, but Mackenzie friend does not let you actually talk. Like, it doesn't let you, other than maybe to say something like, could I approach the witness to show them this document? That kind of thing you might be able to do. But I had a guy who wanted to be a Mackenzie friend to a criminal accused, when what he really wanted to do was play lawyer and plead that person guilty, because he told that person that they were going to we'll just plead you guilty and then you can get back to your life. And I'm like, sir, no. If you plead guilty to this, there will be all sorts of consequences, including deportation. So, like, don't let some rando get
They'll let you get back to your life somewhere.
Yes. A lot of people who get deported back to places that aren't very nice in the first place. It's yeah. So, yeah. He's entirely prohibited from any further participation in this action, and the clerks of the Court of King's Bench shall refuse to accept or file his documents. I love this one. I very strongly recommend that Mr. Temple consult with a lawyer authorized by the Legal Profession Act before he engages in any action before any court in Alberta.
They're trying to warn you, man.
That's what this is. This is, sir, we are not screwing around. And the next step is we're going to make this hurt. So govern yourself accordingly.
Yeah.
But
this is the kind of sentence that I, as a lawyer, am like, now what's happening now? It's like, I read that, I know exactly what they're saying to me.
Yeah. Oh, I mean, I've seen lawyers have, like, I've seen filings where they're like, we encourage counsel to consult with counsel. And that's one of those things where you should be going like, oh shit, you never want something like that directed against you, right? You never want something.
If the court is making suggestions, yeah.
And especially when those suggestions are like, you maybe need a lawyer.
Yeah.
Because, yeah, if the police ask you if you want a lawyer, you need a lawyer. If the court says, we think you need a lawyer, you definitely need a lawyer. Like, oh my God. So Apple Silver says, Runkle, is this order even legal? This order would prohibit him from filing an appeal. He can file an appeal for something that is relevant to him, because they did say he can file documents on his own behalf.
For the moment.
For the moment. I mean, even if he goes to prison, he can file documents on his own behalf.
I was thinking more about the line of being named vexatious. About be like, how about you can't even file your own documents?
I mean, vexatious, they still can. They just have to first go through an application. Like,
Yeah.
hey, court, can I file this?
You know what the answer to that it's going to be at every single time?
Weirdly enough, not necessarily. There was a guy who actually got unvexatious after being declared vexatious because he brought a proper application to challenge his status as vexatious, and the court was like, this actually looks like it cites law. And he's like, yeah, I learned. And they went, oh, okay. And they let him file that, and he brought in, was like, I am real sorry. I was a real dumbass. I have learned that the law is not the things I thought it was. Can I please be unvexatious? And they went, all right. So long, be aware you are on thin ice. And if you start doing crazy stuff again, then we're going to put you right back in the vexatious box. But they actually were just like, yeah, okay.
Wow.
We'll give you another shot.
I didn't know that was possible. Wow. It's a Christmas miracle.
Often these people learn only after they've burned their life absolutely to the ground. Eventually they realize that they have so completely screwed themselves over. And they're like, they turn to their buddy who's been helping them out and go, you promised me all of this wouldn't happen. And they're like, yeah, well, that's a you problem. So, yeah. All right. So, given these factors, I conclude that future abusive litigation in this court by Ms. Thomas is foreseeable. Because why? And that's because she demanded $50,000 in damages from the court in the form of psychological stress over a long period of time, the violation of my right to privacy, property, and an attack on my reputation. So, yeah. On that basis, they order that any statements of claim, applications, appeals, or other documents that initiate a Court of King's Bench process shall include on the front page attention of Associate Chief Justice K.G. Nielsen. I.e., they gots to come to me. He's sending everything directly there. So, clerks of the Court of King's Bench of Alberta shall refuse to file any statements of claim, applications, appeals, or other documents that initiate a Court of King's Bench process unless attention of Associate Chief Justice K.G. Nielsen is on the front. And if they file any statement of claim, etc., then they shall direct that filing to Associate Chief Justice K.G. Nielsen or his designate. So, yeah, all of this goes directly to, all of this is like, yep, this has got to go directly to me, and I'm going to be angry.
Excellent.
All right. That is good root beer, by the way. Do you, are you a root beer drinker? Do you like root beer?
I do like root beer.
Do you have are you picky about root beer, or is it just any root beer is good?
Any root beer kind of will do. Trying to see if we can fix my face so it isn't so red.
I am a little picky about my root beers. There's a few root beers I like and a few root beers I'm not as much a fan of. So, I just, yeah. Oh man, looking at this, Peter Temple guy, I'm just like, I'm looking at his webpage going, How on earth could anybody go, this guy is, this is a person I want to trust my money to?
Oh yeah, don't ask those kinds of questions. It'll make you sad.
It does make me sad. And speaking of people you shouldn't trust your money to, how about Sam Bankman-Fried?
That looks good. All right, we'll go with that color scheme. As I hate my own complexion right now.
You're kind of a little Violet Beauregard right now.
Yeah, I know.
You're bright purple. Okay,
Damn
now
it.
you're more Oompa Loompa or Trump, whichever. There we go.
Whoa,
Now you look like a person, although a very brightly illuminated person.
I'm just good at daylight color. Way up in the color spectrum.
There, I think you had it just a little bit before.
All right, I'm here.
Good enough. We'll go with that.
All right.
So, Sam Bankman-Fried has been ongoing in his, ongoing in his case there, and one has been getting a lot of attention. So let's bring up this document. This is Sam Bankman-Fried wanting drugs. Oop, nope.
Wasn't he already on Adderall twice a day?
I've got to bring up the right page about Sam Bankman-Fried wanting drugs.
Please apply a hat. If I put on the hat, I can't have the earphones. The earphones don't work with the hat.
If you can see right up here, I actually named the file name. SBF wants drugs.
Excellent.
So this is a letter from Cohen and Everdell saying, "Dear Judge Kaplan, on behalf of our client, Samuel Bankman-Fried, we respectfully submit this letter in connection with the issues that we discussed with the court and government on Friday relating to Mr. Bankman-Fried's inability to take his prescribed medication during the trial day." Oh, and I'm being told I got to swoop. Swoop. All right. Now, why might they have an issue with him having drugs during the trial day? And I assume he's got a prescription for this, because no lawyer would be crazy enough to be like, hey, I want my client to have some recreational drugs. Like, you're never going to put this down for meth or for my client needs a little bump of cocaine midway through his day in order to keep going. It might be true, but you're not going to put it into a court filing and you're never going to get it, right? You just know that that's not a thing. But he's saying that, as we noted, Mr. Bankman-Fried has been doing his best to remain focused during trial for the past 2 weeks, despite not having his prescribed dose of Adderall during trial hours. I am going to bet that they were probably not so keen on him bringing Adderall to the courthouse. Why would they not be keen on that? Well, because so many of the prisoners would love to get their hands on the Adderall. And not for attention deficit reasons, but for snorting reasons. So that said, I do have some sympathy for this. I've got attention deficit, and like if you're using medication to manage that, then you should have that. So they say, however, as we approach the defense case and the critical decision of whether Mr. Bankman-Fried will testify, the defense has a growing concern that because of Mr. Bankman-Fried's lack of access to Adderall, he has not been able to concentrate at the level he ordinarily would, and that he will not be able to meaningfully participate in the presentation of the defense case. Now, I'm just going to note here, I do criminal law. The number of my clients who are undiagnosed, unmedicated people with attention deficit is like most. Probably most. The number of them that have what the courts consider a fair trial, notwithstanding the fact that they are, have attention deficit, is So many of them. And in fact, that's true of people with even greater cognitive difficulties than Mr. Bankman-Fried might be having right now. For example, somebody with FASD probably is never achieving a high level of concentration in court. Not a whole lot you can do about that. You can't fix the FASD. Somebody with, I've had clients who were brought in when they were literally just, like coming down off medication, and often not legal medication. I had a client throw up in the middle of court, and the judge was like, "Are we good to keep going?" And the client is like, "Yep, we're good." And I'm like, "Are you sure?" Like, maybe no, like maybe not right now. So, but so they say, we appreciate the efforts of the court and the government to find a way to address these issues. Defense has also attempted to resolve this matter with the Bureau of Prisons, but we've received no response to numerous emails and voice messages. So their plan is to give him a 12-hour extended release dose in the morning before he's transported to the courthouse for trial, which should cover things, right? This is actually a really reasonable request. Like, we just want to give him the extended release, not the quick acting. Can we do that, please? And they say, we're hopeful that this will resolve the situation, but it's not clear that the Bureau of Prisons will actually be able to do this. And we don't know if it'll be effective for Mr. Bankman-Fried. That is also somewhat reasonable, because when you switch up medication, you don't know how it's going to work, right? Lots of people with attention deficit have to jump to different medications. And yeah. They say if this doesn't work, we ask for it to be adjourned for 1 day so that we can try to find something that'll work for the remainder of trial. And if not, we ask that we be able to give him his Adderall at the courthouse.
Mm-hmm.
That actually also seems a little bit reasonable, right? Mm-hmm. We assume that the lawyers are going to be lawyers and they're not going to like slip him some meth or anything like that. So, yeah. If I was the court, I might say, listen, I don't really want it to be you lawyers doing it. Not because we don't trust you, but just because if he cheeks it or something, I don't want you to be on the hook in any fashion. Right? So we'll just have the sheriff give him his meds.
Nice.
Yeah. Now they blacked out all of this stuff, and I'm betting that this blacked out stuff is medical information. That's what I'm betting lives under these black boxes. But yeah, they have been mocking this in some detail. Exhibit A, blank. They've been mocking this extensively in the media, and I actually think it's one of the more reasonable submissions they've made so far. I expect it'll be granted. If I was the government,
some version of it.
Yeah, if I was the government, I'd be like, do it, right? Make it happen. Because I don't want some argument over this. Just do it. Can Adderall be administered rectally? Yes, but the sheriff and his lawyers don't want to. And I don't think we can make his lawyers do that. That would be a funny order. Like, they're like,
the judge will be like, I'll do it myself. I'll shove it right down his throat.
Yeah, the judge is like, I will personally make sure he swallows these meds. Oh, and I've gotten unfocused. I got to fix that. I hate this camera for this. It is the worst for...
yes.
It doesn't remember settings, so it keeps turning on autofocus, and the autofocus is terrible. Because it'll be like, I think we should focus like 50 feet behind you. And I'm like, but there is
camera do you have, Ian?
Behind you. I have a Logitech Brio.
Okay. A little 4K one? That's all right.
Yeah. It should be okay, but it's not great. And the Logitech software sucks. The Logitech drivers they won't remember a setting. So every time they just switch it back to whatever it was from default. So yeah, do not like. So yeah, I actually kind of think like the SBF thing is reasonable. And I kind of, there's so much that is mockable in SBF's case. Like, just why are they going after the one thing that actually seems like it makes some sense? I don't know. You have any thoughts on this one, on SBF and his drugs?
Not particularly. I'm sure he'll get some variant of it. Whether it's what they'll figure out something.
Yep. And
the Bureau of Prisons, yeah, the easiest solution would be if we can get him extended relief at the Bureau of Prisons, because that would make me the happiest if I'm the judge. If not, then yeah, I guess your counselor, if you can get individual packs and blister packs or something, maybe, of these things.
Yeah, that might be a good solution.
Sealed blister packs, then yeah, sure, I guess.
And I mean, those sealed booster packs are, most pharmacies can actually prepare those blister packs if they need to.
There you go.
So, yeah. They should be able to. I wonder if
he continues getting it after he's sentenced. I honestly don't know how that works with medications after sentencing.
He might. It's a lot easier to do so. I've told people before, like, hey, you might want to get a diagnosis before you go into custody, because there's basically no way you're going to get a diagnosis while you're in custody. But if you are in custody with a diagnosis, they should be giving you your meds. That said, the quickest way to lose your meds is if they think that you are that you're stealing them or diverting them or the like. Now, the FTX trial is one of those trials that I'm just super sad is not being published, not being revealed. There are some interesting aspects that we've learned. So one of the aspects of that was apparently they started renaming all of their Alameda things, and just to try to make it seem like they were a little further away. Everybody is throwing SBF under the bus, and SBF is
as well they should.
Yep, and SBF is also trying to throw them under the bus.
Sure.
Like, I suspect we're going to see an effort from Sam Bankman-Fried to blame, is it Carolyn Ellis? I think it's her name.
Yeah,
I'm blanking on her name.
The mousy girlfriend.
Yeah, and I feel kind of bad for her because there's so many commentaries out there that just like make fun of her appearance, and I'm like, I'll make fun for hooking up with Sam Bankman-Fried if you prefer. I mean, the thing is this is.
She apparently thought he was attractive.
I mean, maybe if you like take a lawnmower to his head, like get rid of that hair. I don't know. Somebody described it on Twitter as like, this is the worst breakup ever. And I'm like, yeah.
Up there.
I mean, she's kind of this nerdy girl who, thought she got into this relationship with this, like, freewheeling, billionaire. And yeah. That said, she's getting a whole bunch of jail time herself, so I believe. Somebody was asking, is my dad still in Israel? No, he has made it out. He is back in Canada, so he has successfully made it out.
That's good news.
Let us take a little break here while we what do you call it? While we go over some of the super chats and some of the gifted memberships, because if I get too deep on that, that'll not be good. So Canonical Heat, thank you for 50 gifted memberships. Much appreciated. Icosaplex, thank you for 5 gifted memberships with an icosahedron there as which is, sort of famously known as the D20. It's one of these,
It's
but without the numbers as their
a
symbol.
icosahedron.
Yeah.
Isn't the dodecahedron is 20 or?
Oh, yes.
Icosahedron is 12, isn't it?
Yes, I think so. But
okay.
I'm just trying to look here and see, like, I think it is the D20 shape they've got. So now I'm confused.
We're all confused. I've confused myself. Help.
I have Q's saying they're with 5 gifted memberships, much appreciated. D Novo with 5 gifted memberships, DSN with 1 gifted membership, and Crystal with 10 gifted memberships, much appreciated. And so we've got Icosaplex with a new membership. See, yeah, that's
not D20, is it?
No, it isn't. No, I'm wrong. Wait, 1, 2, 3. There'd be no. That's the D20 shape.
Okay.
Because I'm looking at the D20 as I compare.
Icosa's 20. Deca, 12. Oh, okay. Dodecahedron is 12. Icosahedron is 20. Okay. All right. So I was exactly backwards. I withdraw my previous comment.
Now we are. Now we're
I was exactly backwards.
lost.
I withdraw my previous comment as being wrong.
And we've got Vez from Quebec for your pro bono fund. Thank you so much. I'm hoping to make that into a thing there one day. But here for years, kind of heavy question from left field. Why is Trudeau dragging his feet in replacing Brown on the Supreme Court?
Shouldn't a 20-side die be like Ventihedron or something for 20?
Like at Starbucks?
Or Scorahedron?
So I'm actually okay if he keeps dragging his feet, because I'd be much happier if they wait, and if that ends up being if he ends up like his government falls and the next government appoints a Supreme Court justice, because I haven't been super thrilled with his most recent appointee, Jamal. So yeah, we'll see. So yeah. CG, thank you very much. Says thanks. Natsu Eli with a weird, creepy. Is that a Pokemon card?
It's a bad distortion of one, I think.
That is creepy. Thank you very much for the super sticker, though. But man, that is creepy. AG, years ago, I tripped on a pothole the city had ignored for years in front of Sovsits. They offered to sue the city. Creeped me out. Glad I said no. That was you missed out on a tremendous opportunity to lose a huge amount of money. Because there's all sorts of cases of Sovsits who have managed to turn huge, like good claims into hugely losing claims. I'm going to have to try to find the case where some sovereign citizen ends up winning $50,000 after getting sanctioned for like $150,000. So it's like, congratulations, you've had to pay $150,000 and you've won 50, so you're in the hole. And the judgment specifically said that it was payable to the court to the court first to satisfy outstanding sanctioned bills. It's like, yep, good work. And Lisa says, Google Garfield shooting Pittsburgh, Pennsylvania. He was a sovereign citizen who finally learned that all that information was pure garbage. I'm going to have to check that out. I'm going to have to follow up on that. Rosebud 26 is part of EDB Raid. Welcome all the EDB folks. England DG says, oh, hi, Elf. Hello. The Way of the Wind. Thank you very much for $2. Much appreciated. There's a guy who I was playing in his campaign. It was like a D&D campaign. And he had elves who were very fond of smoking up. And it was about like 6 or 7 sessions in when somebody was like, wait a minute, did you actually create high elves? And he's like, yes, I was waiting for somebody to get that. I was like, you son of a. So, yeah. Did I send a cease and desist letter to Netflix? Netflix used like 4 seconds of my commentary. I don't have any reason to go after Netflix. And I mean, sure,
Production credit.
Maybe I could shake Netflix down for some cash, but at the end of the day, like,
I want production credit. I want my name on the credits.
oh yeah, I'll be like right after like 5th grip.
Also, I want an option for a work yet to be written by me.
That you will not get.
I don't know. I've heard about deals being offered for less.
I mean, what are you gonna do? Like, right? Or I mean, I've got my comes now the Victorian
Uncivil law. The uncivil law story is only uncivil law can tell. Season 1, episodes 1 through 20, dropping 2025.
So he says, get DUI guy after them. DUI guy has one major problem on that one. He's not Canadian, and I am in Canada, and so there are some major wrinkles on all of that. I would probably want to go after them for the Canadian violation if I was going to do anything, but ultimately I just don't think it's worth it. So, nah, we're not doing that. So, will you write a brief to the Senate if you are unfortunately not selected to testify about C-21 starting next week? We hope you get in. I have not been asked to testify. Nobody's been like, hey, we'll get you in there. So I don't think it's going to happen. Every group's got its own people, and I'm not those people. So we'll see. But I may have to write something. The problem is they're doing this during hunting season, which also makes it extra difficult. Krista Peterson, a super chat in honor of today being my 32nd birthday. Congratulations. Happy birthday. Thanks for the company, entertainment, and everything you do. Cheers. Cheers. I'm having a nice gin and tonic in your honor, and I would have had it not in your honor, but now it's in your honor.
Was it to the 5th?
What's that?
To the 5th?
Now I'm confused.
32?
You've lost me.
Happy 2 to the 5th birthday.
Oh. I guess. Don't ask lawyers to do math. We're just not good at it. It's like asking a fish to win a cycling race. It's just not going anywhere. Yellow Pill 17 says govern yourself accordingly equals fact around and find out. Love it.
I have a computer science degree. I used to do my powers of 2 by memory because they're very helpful. That's so long ago.
Wonderful case to start off a Monday legal Funday, Ian. Thanks. Well, I thought so. I hope for a soft sit character in Lawyers and Dragons. I thought about it. I really thought hard about it. And then I thought I will not be able to do it. Like I just can't do it. It's hard to wrap your brain around the right kind of crazy. It would probably hurt the other people I'd be playing with. And I also think that the Law Society might actually take issue with it because the Law Society is famously not good at understanding jokes. DSN, thank you very much for the super sticker. Much appreciated.
But it's happening in a fantasy world. Maybe soft sits are a thing in that world. Maybe they're more correct than in some worlds. Who knows?
Well, the thing is that they'd watch it and they'd be like, you're giving credit to these theories. And I'm like, no, I am making fun of these theories. They're like, we didn't think it was funny. And I'm like,
in the fantasy world, maybe those theories have credit. You ever thought about that, Canada? You don't control fantasy.
And the Law Society's like, actually. So, Traveling Science Man, I didn't know I could do this because YouTube sucks. Support Runkle and Extra Life. Even just sharing with your friends helps. If you look at the chat, it's the mods are occasionally posting. I've got a link to the Extra Life fundraiser, which will be a 24-hour live stream. I can tell you.
When is that?
That is November 4th.
Exciting.
Exciting, especially because I'm hoping to make this a good one, but it is gonna kill me. Like, I'm just gonna warn people in advance. I am gonna be just dead tired afterwards.
I will happily take an hour to shift for you so that you can take a nap or something. I'll
I
put
might
up
have
some
to.
gaming content. We'll play some Fall Guys, or we'll do something. I don't know. We'll figure it out.
I was thinking of pulling an amaranth and just setting up a webcam where I sleep, so people can just watch me sleep.
I have a feeling that that might be more successful with Amaranth than you, but
I suspect so. I suspect that I would have people going, "The hell." I'm not gonna do what
I
I
could
did
dress
last
up
time.
as Amaranth. I could get myself a wig, maybe, and
I'm not going to do what I did last time, which was start out with 4 hours of sleep, because that was not smart. Yeah. Did he sign an upper or lowercase or alternating? Usually they don't like the uppercase. So usually they just like, they get particular. DSN, thank you for 1 gifted membership. Much appreciated. Crystal, thank you for 10 gifted memberships. Those weren't coming up at the start of the stream, and then they started coming up. That's weird on the super chat tracker thing. Ian, check Discord DMs for background on Temple. Thank you very much. I did get that, and yeah, he's a weird guy. Streamlink, please. Yes. For a great time, see Sovereign Citizens Explained by Uncivil Law. I don't know. That guy's kind of sketchy. You might want to. No, you went over Meads and Meads, I heard.
I did at one point. Yeah, it was a good case.
It is one of my favorite cases of all time.
Yeah.
Just because it's the court saying, we have had enough of every flavor of bullshit, and therefore we are going to identify every flavor of bullshit known to us, as well as specifically name some of the bullshit vendors and indicate that we are done. We are not putting up with this anymore. Which, how about Hank's root beer? I don't know Hank's. Dad's is good. Mug is not good. A&W is not good. Mug is one of the best of the like big commercial brands. A&W
root beer floats are nice though. When you do see an A&W restaurant, you get an A&W root beer float. They're pretty good.
They switched to like ice cream pucks, and those are not as good. Back when they did real ice cream, they were good. Sorry, I'm thinking of Hires. Hires is good root beer. So Temple as a speaking engagement / booking site. Oh man, that would be really entertaining to book him at somewhere where it's just people heckling him. And put in like the contract that he only gets paid if he stays there for the full hour.
Yeah.
And just pack a room with people who will make fun of him.
I wish I could help sometimes these sovereign citizens, but they're beyond all help. I'd be like, look, guys, I've read a lot of cases. Okay, I've read way more cases than any of you guys. I've read every significant Supreme Court case, and a lot of ones you guys have never heard about. I read cases all the time. You're wrong on every possible level. Please give up.
The only time I've actually seen them win is when it's like by accident.
Yeah, in spite of themselves. They win in spite of themselves.
And so one person at the one is this guy filed a statement of claim, and it was a bunch of sovereign citizen crap, and the other side defaulted. They didn't respond to it. And the court is like, well, this guy wins, but we are awarding the value of $1, and we're also sanctioning him. It's like, so it's technically you win, but you get $1, and we're also charging you $20,000.
Hey, nominal damages for that win, baby.
There's a lawyer who I won't name who sued somebody, and they defaulted and got $1. I'm just like, that's an ouch. When you're a lawyer suing somebody and the court is like, yeah, you win because they didn't show up, but
depends what you're suing for. I was looking at a cause of action that I was helping someone with, and we're looking potentially for just injunctive and specific performance. And so if we're going to look for, I'm seriously considering just asking for nominal damages instead of monetary relief, because I don't want the money. I
And
want
I
to make
mean,
them do stuff.
that's one thing. If you're actually asking for an injunction, if they got an injunction, that'd be like a different thing, right? Because an injunction, in theory, an injunction can be worth a lot more than money, or than like standard amounts of money.
Yeah.
For
Well, I'll put
example,
in the claim in nominal damages just to keep the case alive, because there's some case law dealing with that stuff. So I'll ask for the dollar just to keep the cause of action alive if everything else kind of fails.
I mean, this is, let's consider like a very weird case. Let's say it is actually determined that, through some weird agreement, the copyright to Iron Man ended up with me. Like the original author, like specifically said, this is not work for hire, and then sold it to like one of my relatives to settle a bar bet, and it ends up with me. This is a hypothetical, by the way. I'm not actually claiming ownership. Um, let's say I went and said, I don't want any money. All I want is an injunction saying that like Marvel Comics can no longer do anything Iron Man. I could still make a ton of money off that injunction. Now, you would also ask for all the money if that was actually determined to be true. You'd be like, I want every dollar you've ever made off of the concept of Iron Man, which would be all the money. Like, you could retire to a private island, and that private island wouldn't be like buying an island. It would just be dumping money into the ocean until it piled up high enough to make you an island, and you could live on that. But like, you could actually just decide to be Lex Luthor with that kind of money.
Okay,
But
okay.
yeah, I mean, I'd be going for like, some sort of really crazy lair. But yeah, it's there are times when an injunction can be worth huge, huge money. So yeah. What is it? I have a different response to long versus short acting Adderall. They're not exactly interchangeable. Yep, I've had similar feelings about long versus short acting Ritalin. They hit me differently. So, how would the court handle someone needing insulin? They're actually very good about this. You get your insulin. And that's because they don't want anybody dying at the courthouse. Do you know how much paperwork it is if somebody dies at the courthouse? And
we're going to
the
keep you
thing
alive
is,
because of the paperwork.
this is a joke, and it also isn't a joke. And the reason why I say this is that there's actually a substantial effect of, if you want somebody to do things a particular way, you should make the bureaucratic hassle of doing it any other way higher than the hassle of doing it the right way. So if it takes 2 forms to do it the right way, the incorrect way should take 3 forms or 4 forms. They actually reduced shootings in one jurisdiction, like police officer shootings in one jurisdiction, tremendously through the application of break open snaps on their holsters. And the way it works is just when you open the holster, when you flip open the the leather or leatherette cover on it, there's a little snap that breaks and it can't be put back together. So that shows that you drew your gun. And they said, anytime you come back with that snap broken, you have paperwork to do to explain. You got to fill out a thing to explain why you drew your gun. And that resulted in the police drawing their gun a lot less often and talking things out, because they're like, I could pull my gun on this guy, but I'm going to have to fill out a form. And the thing is if a form is enough...
ChatGPT to the rescue, baby. He'll fill out the form for me. Oh, fine.
Oh my God, that's going to happen at some point. I want to run that criminal trial where the police officer busts out ChatGPT. Oh, that would be awesome. But the thing is if you don't want to draw your gun because there's a form, then you shouldn't be drawing your gun, right? You shouldn't be... In that case, you should just leave the gun where it is. And although it's funny, I actually talked to one police officer who was really kind of pissed off. And the reason why is because he gets, so they're going to deal with this guy, and this guy is creating a situation. And he's being noisy. He's whatever. He's having a mental health moment. And the police officers show up, and this guy shows up, and he is A, naked, and B, lubricated. He's found himself a great big bottle of like canola oil, and has
Excellent.
yeah.
Sounds like my weekend.
Oh God, no. So he grabs this cop and ends up throwing him down they go down a flight of stairs, and this cop is like wrestling with this naked, lubed up guy, and he doesn't draw his gun in this. But as he's falling down the stairs unsnap his gun, and his gun falls out. And he's like, I don't think it even fell out because there's a secondary retention. It was just that it broke the snap. But it's just like, so he has to write this big long thing saying, I did not actually draw my gun. What happened is I fell down the stairs wrestling with a naked oiled guy, and I hate my life so much, but here we go. And so he's like, it sucks that I had to do that paperwork. I'm like, it does, but yeah. He told me that story on the condition that I don't try to get the documents. He's like, I will hate you forever if you try to get these documents and use them in and use the police report. And I'm like, can I just mention the story? He's like, don't name me. Don't tell him. Don't say where I am. Just, yeah. So, by the way,
to tell me all the places he isn't?
No.
And names he doesn't have.
He's not in Spuzum. That's so by the way, don't do that. That is not a recipe for fun. Getting lubed up and wrestling with a cop. Unless it's consensual. Angie Torres has gifted 10 Ruckler and Bailey memberships. Much appreciated. Ryan Man YYC, thank you very much for 10 memberships. Lynn, thank you for 5 memberships there. Bears Life, hello from the Silent Crew. Hello. God 420, thank you for the membership there. I love the image of Jesus with a giant cannabis leaf. That's a little sacrilegious, but we'll allow it. Midnight Drury, thank you for 1 gifted membership. Much appreciated. Bears Life, thank you for the $5 super sticker there. And that is a very cute cat. Fiona W, thank you for the $20 gifted membership there. Oh, and that reminds me, I got some of these sent to me. F-bombs. So we can break these out in just a little moment here. Katarina Turner, has your father made it home? He has. He's now safely back home. So he had an adventure. I haven't got the full details from him yet, but he had an adventure. And then we've got
wow,
for a pink super chat. Robert Zerung.
That's a thing, man. I might have to steal that. That's pretty cool.
I thought it was fun to play around with. On ADHD meds makes a huge difference in quality of life. I'm going out of country in early November, and Adderall is illegal there. Oof. My doc is super cool, willing to work with me, trying to find an alternative med to substitute. Any thoughts? I mean, check Ritalin. Really, this is going to be governed by what is legal where you're going. So I guess first thing is just check the list of what is legal, because if there's nothing good that's legal there, that you're going to have to. And I get it. I mean, I sometimes use attention deficit medication, but the thing that really I can't deal with when I use it is coming off of it, because you go from that thing of like, I can focus, I can all of this. And then when you're losing that, when, it's kind of like your own little miniature flowers for Algernon every day. And that just messed with me in ways that I couldn't deal with. So I haven't taken meds in a number of years because of that, because it's tough. Like, you have that thing where you remember what it was like to be able to focus, but now you can't. And, it feels so much harder to focus now. And it might be like a rebound effect, but yeah, that's tough. So don't forget, I offered a custom bot for charity thing. Yes, I just heard you talk about it. Yes, I've forgotten the name already. I will have to put up the I'll have to create a list.
Kristen's
But
here. We like
Kristen
Kristen.
Kristen is awesome. Kristen is one
I
of those
like
people.
beef fish. I like beef fish. It makes me happy. Thank you, Kristen, for beef fish.
Beefish is amazing. So we'll have to that
I don't know that Kristen has heard the voice that we've landed on so
oh
far.
god. Oh god.
Hold on, let's
Let
do
me
the
just unplug my my headphones here.
Hey, Kristen. Kristen, thank you so much for helping me come to life. My name is Kelly. I'm a defense. And I love you, Kristen. Thank you for giving me that uncivil. Uncivil loves me so very much. We can swim together all the time. You're the best, Kristen. Cheers.
Oh god. That is yeah. Oh, that is a war crime. Torin 3 says subsets cargo cult practice of law. A little bit, yep. Jeremy Morton, thank you for 5 gifted memberships. Much appreciated. Play craft work while you nap during 24-hour stream. There's a thought. Let's see. Also, really appreciate your support of ADD and ADHD. I've dealt with it since I was in 6th grade. Managed to make it through medical school, but not without a ton of misunderstanding. Yeah. There's a lot of people out there, I think, who have managed despite attention deficit, and in some cases because of. Attention deficit can be great when it works. I've knocked out factums in like a weekend. I knocked out a Court of Appeal factum, which like you got to have on the ball in a weekend. And that was when my brain was just like, let's do the hyper focus thing. And I can tell you, my wife was concerned during that entire weekend because I barely slept. She had to like show up and be like, have you eaten? And I'm like, not since the last time you asked. She's like, that was like 16 hours ago. I'm like, oh. She's like, yeah, you need to eat something. And I'm like, okay. So, I mean, when it's doing that, it's fantastic, right? You can like learn a new topic really in a week or something like that. Like, hey, let's get really into some particular area of contract law. I'm not going to learn all of contract law, but I might learn something really specific about like grain futures contracts or something if you get really into it. And then on the other side, there's the times where you're just like, everything I want to do is so difficult and so brutal that you're just like, why can I not get this basic stuff done? Like even just like, getting a statement of claim done. And a statement of claim is usually pretty easy. It's hard to F up a statement of claim. Lawyers manage it all the time, but it should be hard to mess them up. It's basically just accuse the other side of doing everything. Make sure you have at least some allegations to cover every element of whatever it is you need to recover. And don't say fraud unless you mean fraud. And you don't mean fraud unless you really have fraud lined up, because alleging fraud when you don't have fraud is a way to get hammered.
Yeah, especially in the United States, because that requires specific pleading. So you have to actually like lay out a lot more detail in your complaint than you normally would when you lay out a fraud claim. So best to avoid the word if you can.
And in Canada, if like, at least in my jurisdiction, if you say, I think the other side did something fraudulently, and the court finds that they didn't do it fraudulently, even if they might have done it, but the court finds it was accidental, the court may end up going, okay, we're giving you 20,000 for your money back, minus 10,000 in FU damages for saying fraud when it was not fraud.
Yeah.
They are cautious about that. So you got to be, but I mean, the other thing is if you can establish fraud, then you want to claim it, because the court will hammer people if they're doing actual frauds. So
Yeah, you just want to, actually have it. You don't want to. It's like RICO. It's one of those things you don't want to mention unless you have it, because it tends to be overused, and courts look at it and they hate you. So it's like you better have it.
Yeah, you don't just throw it in just because, right? You have to actually demonstrate it. And I mean, I've seen some cases where they're like, you alleged fraud, we don't think you made out fraud, but you came pretty close, so we're not imposing any punishment damages on either side. You want to at least be credible on fraud. The other thing I've seen is a statement of claim that said, we think fraud, and then they ended up basically asking for and getting permission with consent from the other side to amend their statement of claim, even though it was past the deadline. The other side was like, we'll agree to it. And they basically were like, after discovery, we realize it wasn't fraud. It just really looked like fraud because these people are such tremendous screw-ups. And so they actually wanted to back away from the fraud claim because any sufficiently advanced incompetence looks like malice. It's was kind of their problem. So it was like, we're just gonna say that you guys are screw ups, but it looked like fraud to us from a distance. And Vez from Quebec, I just pledged the 80K. You can keep the car. Nice. What is Mr. Temple's LSAT score? 82. Robert Zerung, thank you very much for the YouTube membership, and holy crap, for 50 gifted memberships. Thank you so much. Wow. And Yellow Pill, Uncivil Law, you triggered all of my cats, lol. The cats did not like the B-fish voice, apparently. Hyperfocus is a superpower, mom of 2 ADHD kids. I always say that attention deficit to me doesn't feel like a lack of attention. It feels like a lack of control of attention. It's like you've got a powerful spotlight, but there's some asshole controlling where it points. And you can send this guy a request by letter, and he may or may not point it where you need it to be. And so you're like, I really need it to be, I want to fix this car. I need you to shine the spotlight on the car. And the guy's like, nah, squirrel. I'm going to shine it on the squirrel because the squirrel's awesome. And you're like, dude, car. And he's like, nope, squirrel. You're like, stop it with the squirrel. And he's like, stars. Just come on. But sometimes he's like, right, car. And then it's golden, right? It's then you've got everything working perfectly. Because I've had the experience. I was outside and I was reading a book, and I didn't realize how sort of in depth I was in until I was finding it that I couldn't read the book anymore because the pages weren't turning properly because the rain that I had been ignoring had soaked my book. And I'm like, this is it being too much of a pain in the butt to turn the pages because they're falling apart now is what snapped me out of reading the book. And I was like, how long have I been sitting in the rain? Meanwhile, my parents were freaking out because I was outside somewhere. I'd wandered off to to a clearing nearby, and it's been pouring rain, and they're like, where the hell is he? And I come back just completely soaked in water, and they're like, where were you? And I'm like, I was reading. Also, they were not happy because it was a library book, and the library was not happy. So, yeah. I guess let's do a swoop. And yeah, that one. All right. This is one. Have you seen this one? In the court of the state of Oklahoma, John Kane the Fourth, Chief Justice of the Supreme Court of the state of Oklahoma, versus Tracy Soderstrom.
Uh-huh.
Tracy Soderstrom is also a judge in Oklahoma for now.
Sweet.
For now. So the story behind this one is it starts with her texting. And when I say her texting, the context is important here because this was in the middle of a murder trial. Guy was on trial for murdering his kid.
Okay.
And there's a courtroom camera. And she was on her cell phone texting. And so somebody recorded the courtroom, footage and caught just how much she was texting. And so that got some interest. That got some interest on all of that. And she got brought in to answer some questions about this. And then it gets even
spicier.
Worse.
All right.
And the news has been reporting on this one about like, hey, it's just about the texting. It is so not just about the texting because every allegation in this one is worse than the last allegation.
On just a technical level, what the hell is the court on the judiciary, the trial level? Is it different than the Supreme Court of Oklahoma? Is it the same thing as the Supreme Court of Oklahoma?
I don't know. And somebody says, was she texting about the case? Oh, yes, she was. Oh, my, yes. And that gets her into so much shit. We are 8 minutes away from me actually being able to say that. What am I doing? All right. So this petition is filed pursuant to the Oklahoma Constitution. And this is basically judicial complaints. The respondent, Tracy Soderstrom, is now and has been a district judge, but will not be for much longer if this is made out.
So far, I've got Tracy's back just because it sounds fun.
Fair. In Lincoln County, in the 23rd Judicial District of Oklahoma, which includes Lincoln and Pottawatomie counties. What's that?
Pottawatomie, I think is how it's pronounced.
Okay. Like that's a word. So she's a judge. She was elected in November of 2022 and took the bench in January 9th of 2023, which means that she's been at this all of like 15 minutes. This is not somebody who's been a judge for a long time. She is a baby.
You bring it, Tracy. Judge. You show us the way.
And it also means that she has not had a lot of time to engage in misconduct. So she had to hit the ground running. I see Pottawatomie. I think that's Pottawatomie. Potato.
Yeah, now they try to teach you how to pronounce it, and it's always fun.
So, the grounds upon which they're seeking to remove her from office on the following grounds: 1, gross neglect of duty; 2, gross partiality in office; 3, oppression in office; and other grounds specified by the legislature. Just like everything else. All the things. So, her conduct violated the following canons and rules. Note, canon, C-A-N-O-N, is like a doctrine. So you have religious canon, which is like the rules you follow in religion. You also have canon in like comic books as to, what things are real in that comic book universe versus which things are not. And I'm not making fun of the town name. I just don't know how to pronounce it. That's That's the thing. That's on me, but you run into things and you're just like, I'm not really sure. But this is differentiated from Canon CANNON, which is a big firearm used to sink pirate ships and also used by pirates to sink other ships. So a judge shall uphold and promote the independence, integrity, and impartiality of the judiciary and shall avoid impropriety and the appearance of impropriety. And a judge shall comply with the law, including the Code of Judicial Conduct, and shall act in all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety, and must perform the duties impartially, competently, and diligently. And so there's a lot of elaboration on that.
Decorum, blah, 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 blah. Yeah, that's fine. What you do?
All right. Yeah, let's skip on to what she did because this is long. And so we could go through all of the rules that they say she broke, or we could just talk about what's happening. So while presiding over a murder trial beginning on June 7th, 2023, which hence they're going to call the murder trial, the respondent exchanged over 500 text messages with her bailiff, Angela Miller, in which they mocked the physical appearance of attorneys, jurors, and witnesses and used offensive language to deride the state's attorneys.
So now, I have a pure practical question at this point. So the judge is on the bench, and presumably the bailiff is also in the courtroom at the same time. And what, they're just texting each other, and like no one is noticing that like there's this texting going back and forth.
Somebody did notice, which is how this ends up happening. But I'm just like, 500 text messages? I can tell you, I haven't sent 500 text messages to my wife in like the last month. This is a crazy amount of text messages. 500. So, yeah. The respondent and her bailiff called murder trial witnesses liars, admired the looks of a police officer who was testifying, disparaged the local defense bar, expressed bias in favor of the defendant, and displayed gross partiality against the state. So some of the bigger allegations are the gross partiality aspects because like they're all like, oh, they're texting. And yeah, there is some serious Mean Girls bullshit that goes on in this. We are 3 minutes away. Come on, Ian. You got to hold it together for 3 minutes and then you can use all the words. And Nicholas Starro has an excellent point. So she's a YouTuber in waiting. She would do fantastic on YouTube. Like a lot of this stuff would be just fine.
She may indeed join us in the annals of LawTube. She does. She's more than welcome to appear on my channel. We'll help her get her start.
Oh, absolutely. I mean, but the thing is if I became a judge, like if they were like, hey, Runkle, we want you to be a judge. The first thing, like I'd make one more video and that video would be, hey guys, it's been real. I have to be a judge now. So every video is going private. And that would be the only video that stays up is just, hey guys, it was a lot of fun. Gonna miss you. Bye.
I've been consulting those rules of ethics real hard on what I can and cannot do.
The rules of ethics here basically forbid any public commentary on like law. So it would be very, very difficult to maintain any sort of channel. I suspect I would even run into trouble making commentary on US laws only. So yeah, it would just be, there'd be one video left.
I think if I stayed out of my jurisdiction, I think I'd be okay, but I'd have to double check the canons of ethics.
Yeah, here they're pretty strict. So, yeah. Respondent and her bailiff texted back and forth with each other continuously during the active portions of the murder trial. This is significant because she actually denies that. Respondent placed her personal cell phone towards the front of her lap outside the view of others in the courtroom. So she's hiding it. Respondent was scrolling Facebook, accessing various phone applications, and texting for extended periods of time during the murder trial. Now, the thing is, I get it. Murder trials are boring. Almost every trial is boring for large portions of the trial, right? And murder trials are the interesting ones. Actually, that's not true. Murder trials tend to have more boring stuff than, say, an assault trial. Because like a bar fight, you're basically probably going to have one, maybe two witnesses. You're going to have guy who got hit in bar fight, and you might have the accused saying, I didn't hit him, or yeah, I hit him, but it was self-defense. That's your trial, which means you've got a couple of witnesses and they're both interesting, which is great. That's like 100% interesting witnesses. Murder trial, you're going to have a blood spatter expert who's going to be sitting there talking for hours about, well, the teardrop shape in this case indicates that the direction of travel of the moving object that was dripping the blood was probably this direction. And I feel that I'm relatively confident in assessing that that was the direction of travel, indicating that there was a bleeding or blood-covered object that was being carried in this direction. Now, this mark is a drag mark, and this mark is a spray mark, and this mark is a skid mark. And, it's like, eventually you're just like, oh my God, shoot me. Because you can look at the murder trial.
Replicate the murder case. It'll be faster. Just shoot me. That way you can show me.
I mean, you can look at the murder scene and be like, okay, it's very clear he got shot in room X and dragged out through room Y, because the big puddle of blood and the bullet hole are in one room and the body ends up in the other room. Do we really need this blood spatter expert to tell us that, that this is how it went? No. So a lot of that stuff gets boring, but people are very careful on in murder trials. Like, the prosecution is going to be extremely careful, and they're not going to be like, we'll just skip the blood spatter expert. He's boring. Because the last thing they want is for the jury, or if it's being heard by a judge, because in Canada, a lot of murder trials might be heard by judge alone, to be like, well, I didn't have any evidence on the blood, thing, so I'm acquitting. So, and I'm being told we are at an important time this time. The other thing about murder trials is that you often don't have a lot of direct evidence. Because if you have direct evidence of like, hey, I saw Bob kill Joe, you might not be having a trial. A lot of murder trials are circumstantial evidence, which is like, hey, we're pretty sure Bob did it because Bob was the only person over at that house, and then Joe is dead. How the hell else does that happen, right? And in most criminal cases, the victim testifies. Not so much in murder cases for fairly obvious reasons. So, yeah, I get that it's boring, but this is an important thing of judgery, which is you got to pay attention during the boring stuff. Yeah. The bailiff, sitting in a witness box or at a small desk near the respondent, sent and received text messages during the murder trial as well. On a separate occasion, the respondent and bailiff discussed by text which jury instructions would best fit their desired outcome. That is not cool, because first, the judge should not have a desired outcome in a jury trial.
Yeah.
And second, like, the judge is supposed to be the law person. The bailiff...
And also, that information should be going to counsel.
Yep.
If the judge is like, you know what? Yeah, it's like, I know you had some really great suggestions from some jury instructions. I have some great suggestions. Here's what I think.
Yep.
Then you would send that to counsel so that they could present their arguments about why those instructions are good or not, and then you can, overrule them. But still, like, due process is a thing. I remember reading that.
I mean, that's what we read.
Yeah.
But now after publicity regarding the
and you can do that incidentally, just by the way, for what it's worth. Although it doesn't happen frequently, but it does happen occasionally where a judge will do something that neither party asked for or neither party wanted. Or otherwise do something that's unexpected, because it's like, well, the prosecution says this, the defense says this, I'm going with option number 3. So that does occasionally happen. So I always find that cute when that happens.
I was just dealing with a case a little bit ago where it was like an appellate case where the judge was like, So you guys were both arguing this issue. We actually want you to come back and write submissions on this other issue entirely, and ruled on the basis of that other issue. So
Supreme Court's done that occasionally. It's like, we're not taking any of your questions presented. Here's the question we want to have discussed. That's what we're discussing now. Yeah.
Oh, the Supreme Court does this all the time. I mean, the Supreme Court sometimes will be like, you have this really interesting constitutional issue that we don't want to deal with right now, so we're going to find some other reason to toss this out. It happens. Like, Supreme Court's got all sorts of ways to punt things out. Now, after publicity regarding the respondent's excessive phone use during trial, so this made the news, the respondent had the security camera moved where she could not be observed. Now, personally, I would have just been like, my cell phone goes into my drawer and I don't have it when I'm in court. Not this judge. This judge is like, we're going to have the camera moved. The camera is the problem. When the camera was subsequently returned to its original location, a black box was inserted to block out the bottom half of the viewing area so that the respondent could not be seen. The blocking was eventually removed. Specifically, other judges were like, this is stupid. Stop it. The pattern of conduct demonstrates her gross neglect of duty, gross partiality, etc., and demonstrates her lack of temperament to serve as a judge. The respondent's actions giving rise to these charges appear more fully set forth in the following specific allegations. They're going to get real particular. The Martzell case. Christian Martzell and Judith Danker were charged in the Lincoln County District Court with murder in the first degree for the death of their child. There's a prosecutor in Edmonton who's a Jennifer Danker, and she's actually quite a nice person. So that's who I think of, but no relation, I hope. Danker entered a plea to Judge Ashwood in 2019 on an amended charge of enabling child abuse, for which she was sentenced to imprisonment for 25 years. Martzell was held in jail without bond until his jury trial began on June 7, 2023. State was represented by Adam Panter and Assistant District Attorney Ryan Stephenson. The defendant was represented by Velia Lopez and Greg Graves, Capital Trial Counsel for Oklahoma Indigent Defense, i.e., he's got a pair of public defenders. And the reason why he's got public defenders is because it looks like they might have been seeking the death penalty. Capital Trial Counsel, that's what that reads to me. I see you're nodding. 4 weeks prior to trial, the state filed a notice of endorsement of personal witnesses to include a Dr. Ryan Brown, MD, as a witness. And the defendant filed a Daubert motion. Daubert?
Yeah, either way. I always say Daubert, but I think I say Daubert, but it's technically Daubert.
So basically,
I
they're
pronounce
saying,
it wrong.
Is this guy qualified to testify? Is what they're asking.
Yeah.
Is he testifying to real science?
Yeah, exactly.
The respondent did not hear the motion at a motion hearing on May 3rd, 2023, and took the motion under advisement during following the jury trial call docket. Now, this is important because this is her engaging in some this is the allegation, is that she was engaging in some fuckery on this. And we could say fuckery because we're at 2 hours and 9 minutes, and we rolled the spicy time. An assistant district attorney asked that the court rule specifically on the motion prior to the jurors being sworn, and alerted the court that the timing of the ruling would determine whether the state could appeal an unfavorable decision. The reason why is the U.S. has very strong double jeopardy provisions, much stronger than in Canada, which means once the jury is sworn, they don't get appeals on this.
Pretty much.
But before the jury is sworn, they can appeal. And they can. Yeah. So on June 7th, the court took up outstanding issues before voir dire, but then brought in the jury and stated she would take up any remaining issues later. The ADA again asked that the evidentiary matters be settled before the jury was sworn, and the defense attorney agreed, saying they liked for the motions to be argued and solved so they know what they can ask and what can be said. Defense and prosecution are both saying, we should hear this motion now, please. And she's going, Nah. Respondent, the judge, said they will maybe take it up that afternoon when they got to the point of swearing in a panel. While the district attorney was addressing jurors during voir dire, respondent texted that he was sweating through his coat, to which the bailiff responded, "Yes, it's gross. He's gross and a horrible speaker." I mean, this might be commentary on LawTube. It's not good commentary on LawTube, although we do sometimes, like, we're all human. We make this commentary. You shouldn't be doing it as the sitting judge.
I'm going to give the judge a pass for like their comments as to their perceptions of the witnesses, because unless it impacts their rulings, because the judge can have an opinion themselves about what they think. Well, I'll still give him a pass, because I'm sure judges have many thoughts about the attorneys that appear before them. I'm more interested about the legal errors that pop up in their rulings more than, I don't like this attorney.
This goes towards bias, and the thing is putting any of this stuff down is great for papering a bias claim against you later.
This is fair. This is fair.
Regarding the assistant district attorney, the respondent commented that they're going to hate him, referring to the jury as they. The bailiff responded, "Absolutely, he's an arrogant asshole." The bailiff then made a crass and demeaning reference to the prosecuting attorney's genitals, to which the respondent replied with a ha-ha icon. Now, I'm just going to say the judge should not be having discussions about the lawyer's genitals.
No, that's not great. That's a little bit harder. That's a little bit harder to justify my previous analysis.
Yeah. I mean, it's one thing to be like...
I'm having a tougher time making that one work, Ian.
Yeah, going like, hey, this guy's arrogant and might not play well with the jury. Okay, like, fair. Talking about his, meat and two veg is not really a good approach.
Well,
the DA made a reference to a BLT sandwich, and the bailiff remarked that the defense attorney threw his BLT analogy back at him. The respondent replied trash with various emojis to reference trash and a BLT.
I don't know what that's supposed to mean, so I'll let that go.
Yeah, this one is confusing as well. I'm just trying to imagine the circumstance where you would make a BLT reference with the jury. And I mean, I am kind of known for making weird references. In front of the Supreme Court of Canada, I called a police officer error a 10 beer, like I described it as like more 10 beer conduct. I still don't understand where the BLT would be going on this one. So at no time during these exchanges did respondent admonish her bailiff not to discuss the attorneys appearing before the court in such an inappropriate way. Instead, the respondent joined in on the commentary by again referencing the DA's appearance and stating, "Why does he have baby hands? They're so weird looking." The bailiff replied, "I was told they were tiny, lol." Now, I feel bad for these lawyers who now have all of this commentary put into the public record. Like, all of this, now everyone's going to be going, but do they really have baby hands? Conversely, when the defense attorney addressed the jury during voir dire, the respondent remarked, "She's awesome." The bailiff responded, "Yep, and she's so smart." Following voir dire, the judge sought to swear in the jurors, and the state objected, again requesting a ruling on Dr. Brown's ability to testify, and noting the state would lose its right to an appeal and double jeopardy would attach once the jurors were sworn in. The ADA said he thought all parties agree the matters would be taken up before the jury was sworn in. The respondent overruled the state objection and swore in the jury. This is difficult to justify under the best of circumstances, where it's just like...
it's a little hard to adjudicate on the naked record as it's expressed, because it depends on so much. It depends on the timing of when witnesses were made available to the judge and all kinds of things, and the judge's desire to fair. Like not F around to find out, because the judge is like, look, we're swearing in the jury here at 8 a.m. on Tuesday or whatever it is. And it's like, oh, I got this last minute thing. No, you don't. We're swearing in the jury 8 a.m. Tuesday. Let's go. So it's a little bit hard to adjudicate in the naked about this. I mean, also like exactly
the
scope of this thing, because Dobert hearings can be, to strike completely, or it can also be limit testimony. So I don't know that one. I'm not sure.
The other
Also,
thing on
ideally,
this
if it's also it's a death penalty case, and if your case is hinging on the one guy, like if this one doctor not testifying is really going to blow your case completely apart, dude, it's a death penalty case. You probably should have it backed up 8 different ways.
Yep.
Just saying.
But the thing is like this judge is writing basically a statement of claim here. Like this is, and all of those comments about like the lawyer's dick, help this judge frame this as massively egregious. It might not end up being so egregious at the end of it.
I agree. I agree completely. See, this is the problem, because you have these things which could be fine, and then you have other things which are not fine, and you kind of like taint the entire thing. So
this is kind of like deciding to go for a walk late at night and deciding to wear like a balaclava and carry a big bag with a dollar sign on it. If something bad happens, you're going to have a much harder time explaining what you were up to if you were out late at night with the balaclava and your dollar sign bag and your crowbar than if you were just out there like, you know, like a normal person, right? Once you end up doing all this like shady stuff, it makes everything around it look shady too.
Yep.
He says, I joined and the first thing I hear is something about a dick. I'm sorry, Iggy.
We're doing a dick measuring contest apparently in Oklahoma.
The Daubert hearing was held 2 days after the jury was sworn, and the respondent sustained the Daubert motion, and Dr. Brown was not allowed to testify. So, and now they can't appeal, where otherwise they might have appealed.
Yeah.
During opening argument, the respondent continued to praise the defense attorney by texting her bailiff, "Can I clap for her?" Referencing the DA's office, the respondent noted they're not used to going up against competent attorneys, implicitly dismissing the capabilities of the state's attorneys and the defense bar as a whole. I can just say, if I'm a defense lawyer and I hear this, I'm going to have some questions about her on any of my files, right? When the DA began to question witnesses, the bailiff texted, "He's horrible," to which the respondent replied true. The bailiff replied, "Sucks," with 4 S's. 5 S's, I guess, technically, but 4 at the end. While a video was played to a witness on the stand, the respondent remarked to the bailiff, "This shit is boring." And you know what? It probably is. I can tell you, the Depp trial, that one day where they played entirely video depos.
I was bored. I was watching it.
I had 4 hours of sleep, and I was sitting there like trying. I had my pen, and I was like digging my pen into my thigh so that I would stay awake. I'm like, I can, because the sheriffs were saying, or the bailiffs were saying, that if you fell asleep in there, they were going to yeet you. So I'm like, must stay awake, even though so boring. So boring that I was just like, you know, video anything is more boring than in person because you don't have that, you know, you don't have that interplay. I would be more interesting, audience, if you were in my, you know, my room right now. I'd be very confused about how you all got here, but I would be more interesting. And the thing is videos that are played often are super boring. I have played for the court a 2-hour cell block video where I was like, can I play just the portion where a thing happens? And the prosecution is like, we object. We want the whole video to be seen so that we've got the proper context. And I'm like, but I really only care about like a minute. And the judge is like, the prosecution is entitled to require the whole video be played.
They sure are. They sure are entitled to, but
the reason why they wanted the whole video, by the way, is that there's a point where my client took his pants off. and like spent like 20 minutes running around with no pants in his cell before he, and I was just like, but most of the time he's just like sitting on the bed and he's, whatever else. So like it's super freaking boring. And even your client taking his pants off on a cell block video, super boring. It's like this grainy video of some dude with no pants. You're like, all right, now he's got no pants on. And then 20 minutes of that, and you're like, okay, now his pants are back on. Super freaking boring. Yeah. All right. While an interview was played, the bailiff mistakenly thought it was a video the state had previously lost. Respondent texted, they didn't lose this one, but they should have. Bailiff replied, it doesn't help the state at all, to which the respondent affirmed by texting, nope. Later, the respondent texted, state just couldn't accept that a mom could kill their kid, so they went after the next person available, evidencing her opinion.
She is born to be a YouTube commentator. She's born to be a YouTube commentator. This is what we do. She's great. She's great. Yeah. She's just doing exactly what you and I would do on a trial. This is working. Great. This isn't working. This attorney's making sense. This one isn't doing. This guy's an idiot. Whatever. Yeah, this is what we do. She's trying to take our job.
They took our gerbs.
God damn.
It's a great YouTube. This is great YouTube commentary. It's not good when you are the presiding judge. So respondent later texted, this is dumb. During the direct examination of a witness, bailiff replied, I just hope the jury doesn't buy his shit. The respondent commented, he looks constipated, and is that the oh shit look? Can I please scream liar, liar? Referring to a co-defendant. When a police officer took the stand, the respondent texted, he's pretty. I could look at him all day. To which the bailiff replied, same, lol. You should not be like eyeballing people as if they're beefcake during a trial. And if you think that this one's not a big deal, picture the judge being a creepy 70-year-old guy saying the same thing about a young police officer. I could look at her all day. Like, you would not think that was okay. They comment as to whether one of the jurors is wearing a wig. So they wondered if another witness had teeth, and the respondent texted no, star witness right there. I can tell you the wig, teeth, like that sort of thing. Keep in mind the people who are often witnesses and participants in a criminal trial might be living lives that are harder than yours or mine or Kurt's or anybody else's, right? You're going to have a lot more people who have lost teeth due to not being able to go to a dentist. We'll have a lot more people who have lost teeth due to being in a fist fight or, anything else, right? So, you're talking about people who are coming from poverty, coming from misery, coming from all sorts of things, right? Yeah. Later, the respondent offered her opinion that to the bailiff, the DNA excluded Marzal on the bed. No way they get guilty on murder. So later, the respondent approached Sergeant Kelly Coleman, Captain Chad Pavlicek, and Detective Larry Stover in the hallway and stated that the co-defendant was not believable. She did not think the defendant would be found guilty of murder, and he would be only sentenced to credit for time served. This is midway during the trial. She granted the defendant's request for an additional instruction for manslaughter 2, which carries a sentence of 2 to 4 years. She took the state's request for a murder 2 instruction, which is an 85% crime with a punishment of 10 years to life in prison, under advisement, i.e., she didn't give that in. She didn't put that to the jury.
Mm-hmm. I'm assuming what 85% time here means that it's a determined sentence, and you have to serve at least 85% of that before you're available for parole.
That's my guess.
That's what that means.
Yeah.
Yeah. That's incidentally
So-
the rule in the federal system, in case you care. So I'm just assuming it's a mirror.
So they said, so bailiff responded, so basically mom taking the plea deal screwed him over. Respondent reassured the bailiff, no, man, manslaughter 2 is 2 to 4 years, enabling is 255 to life. I'd rather give the man 2 instruction. The bailiff responded, and he's already served that. Respondent replied, yep. They're talking about how to get to this outcome of time served. Later that day, the respondent denied the state's request for a murder 2 jury instruction on the basis that the request was made without sufficient evidence or notice. The state then requested an enabling child abuse instruction instead, and the defense objected because there was a dead body, arguing there's case law to support the objection. The defense ultimately withdrew the objection because the case law mentioned did not support their position, and the respondent then allowed the enabling child abuse instruction because they'd have had a hard time with that. Jury found the defendant guilty of manslaughter in the second degree, so the second degree manslaughter, and sentenced him to time served, a sentence only a judge can impose. Respondent accepted the verdict and imposed a sentence of 4 years, giving credit for time served, resulting in no additional jail time, which is what she told the cops she was going to do before she did it. That looks real bad. In baseball, it is a badass move to call where you're going to hit it. Like, hey, it's going to be a home run right over there. And if you could pull that off, that is baller. In criminal trials, as the judge, that is the worst thing. Like, you should not be doing this. This is so wrong. So wrong. And like the texting at this point kind of feels like an afterthought, right? Compared to like the possible bias issues.
The problem is without the texting, you can't make any of this work on the law.
It's true.
Without the texting, the judge can justify every one of these decisions, I'm sure.
But the texting is the evidence, right? It's not the crime.
No, it's the evidence that things are not well afoot. Yeah, the judge, for better or worse, gets quite a lot of control over their courtroom, including, order of trial, what witnesses are allowed to be called, and Dober, and motions in limine, what questions can be asked, the order of jury instructions. They get a lot of discretion, and especially when that discretion is used in favor of the defense. There's like no appeal possible because double jeopardy issues. So it's like without the text messages, it would be really difficult to show the judge did something wrong.
And I'm actually surprised because normally when I hear this kind of like misconduct, it's in favor of the prosecution, in favor of conviction.
That is a little bit odd too. Yeah, that's normally a little bit odd that it's so anti-prosecution, anti-state.
It's weird. Like, I was just like, wow, she's actually going against the prosecution on this one. But as a defense lawyer, I'd be uncomfortable, right? Like, and the thing is in Canada, I can tell you what the result of this would be. This would be new trial. In the US, this is not new trial.
That's right, baby.
And if this hadn't happened, this guy might have been convicted of like murder of a child. Are we okay with a child?
Unless you can show the judge was bribed. Unless you can show the judge was bribed, then you can do a new trial. But
is that the only exception to like second or double jeopardy issues?
Well, because at that point you'd make the argument that there's no double jeopardy because the defendant was never really in jeopardy in the first place because the fix was in.
Fair. I like the argument. Now I want to read some case law on that. That's fascinating. All right. After becoming aware that a 51-minute video snippet of the trial had been publicized showing the excessive amount of time on her phone, the camera was moved to exclude her desk from view. I'm not going to play a 51-minute video. I've seen it. She's on the phone a lot, but I'm not going to play a 51-minute video. They note the move left a gaping hole in the ceiling. The camera was later moved back to its original location, but a black box was inserted to block out the bottom half of the viewing area so that the judge's desk could not be seen. And the county commissioners then voted to remove any obstruction from the camera's viewing area, reasoning that the respondent was not the only judge using that courtroom, and the other judge, Judge Mueller, did not have a problem with the original placement. And while on vacation, Judge Mueller received a phone call from a courthouse employee who told her that the respondent, the judge, said she either can't be trusted and/or better watch her back in light of the county commissioner's decision. Trying to intimidate a judge is always a bad idea, because the judge always has more cards than you think. So when the respondent testified before the council on judicial complaints about these matters, she stated that she was texting about things that were probably could have waited, instead of recognizing that these types of communications should never be made at all. This is a problem, right? Like, if she'd said, I effed up, I shouldn't be doing this, I'm going to just not have my cell phone in the courtroom anymore, I feel like they would be in a much better situation. But being like, I shouldn't have said it at this time, is the wrong answer, right? That is the wrong answer, so much so. And I'm being reminded that I should remind you guys, please like this stream if you haven't hit the like button already. It is free. It will cost you nothing. Push buttons, wiggle joystick. If you have ever played the old arcade games, that will be a little bit of nostalgia. And also, if you there will be links to the fundraiser, the Extra Life fundraiser. So if you want, you can contribute there. I'm trying to beat out my previous year of 50 grand. It's a big goal. I don't think I'm going to make it, but Kristen M96 has donated a, she's going to make a robot for the winner. And I, amongst other things to auction, I have this rock.
Okay.
A lot of people expressed interest in owning this particular rock.
We got $5 for the rock.
People have already offered a lot more than $5, believe it or not. We're going to auction it live for the fundraiser.
Excellent. I look forward to bidding on the rock.
I did a video where I commented about self-defense weapons, and I noted that the rock was a better self-defense weapon than this thing that is banned in Canada. And I was like, you can have this rock for the low price if I forget what I said. And I said, I'm just kidding. I'm not actually selling the rock. I got a lot of people sending me requests for the rock. They're like, seriously though, how much for the rock? So people are saying they want the rock embiggened. Give me 1 second.
Yes. Can you make it full screen? Tell us, do a little event. Do you want me to describe the rock, a little Vanna West style or whatever? Yes. Take a look at this wonderful rock made of this rock-like material. It is a wonderful shade of yellowish gray. It comes in a hard, firm package with bumps and design. Kind of looks like a whale a little bit there with the dot on the head and stuff. And you can use it for paperweights and bludgeoning. It's rock. Not a potato, actually rock. I
will probably have to do like some sort of certificate of authenticity of the rock. I literally just got this out of my backyard. So yeah, the rock. All right. So she also attempted to mislead.
You can
the
also use it
judicial
as a
council.
pet.
It will make a pet if you want. So she told the judicial council, saying that the text messages were when a witness would come on or off, or when there was a pause. However, the timing of messages aligned with the time on the video and shows the texting did not occur during breaks. When asked if she recognized it was inappropriate at the time, she explained it was like, "Oh, that's funny, move on." So she lied and said, "Hey, I just did it during breaks." And she forgot that the one thing lawyers are really good at is checking receipts. And
Yeah.
so, like, as a lawyer, somebody says, "Oh, I just did it during breaks." The first thing I'm doing is going like, "All right, let's run the timestamps against testimony, and we'll we'll check this, because yeah." So the totality of the text messages give the appearance respondent believed the defendant was innocent and that she
Yeah.
wanted a particular outcome in the case. That appearance, the various decisions she made during the case, such as refusing to rule on the Daubert motion and denying the state's request for a murder 2 instruction after privately expressing her personal preference for a particular jury instruction, give the appearance that the respondent may have taken actions in furtherance of that desired outcome. The judge is not supposed to have their finger on the scale. And that's what they're saying here. So, absence of objectivity and wholly abandoned her neutral role. Oh, but it continues.
I'm sorry, what's this next paragraph that's happening now?
It starts getting weird.
Sorry, I skipped ahead. What's happening now?
It starts getting weird.
Okay.
So, in late January, the respondent told a courthouse employee she was going to have men photographed in the hot pink chairs in her chambers, and her bailiff was going to hang the photographs on her wall. Respondent specifically declared it would be funny. Thereafter, the Council on Judicial Complaints received an allegation that the male attorneys were being asked to pose for pictures in the pink chairs, and the pictures were being displayed in the respondent's outer chambers. There were no pictures of women in the chairs. Some of the men reported feeling uncomfortable, but they did not feel like they could refuse. Because how are you going to turn down a sitting judge that you might have to appear in front of later? And who looks like they might be playing favorites, right? Assistant District Attorney Rachel Thompson told both the respondent and bailiff Angela Miller that the wall of male pictures was sexist. Prior to this comment, the bailiff asked defense attorney Shelley Levisse if she wanted to take a picture in the chairs for the sole purpose of making it seem like they were not being sexist, and Levisse declined. She's like, "I am not providing you with cover on this," right? After the ADA's comment, the respondent did not ask the bailiff to remove the pictures and commented to her bailiff, "You're going to get me in trouble with these pink chairs." After receiving the council's inquiry, the respondent denied that any attorneys were being forced to have their pictures taken. Yes, it's just a voluntary request from a sitting judge.
Oh my God.
If a judge asks you for something, it's not voluntary. Like if the judge says, "Hey, can I borrow $20?" You're giving them $20. Which is why I have never been asked for $20 by a judge in the history of time. And it will never happen, right? Like, judges are very careful. I can tell you, I have been out for a lunch with a judge. And I was like, "I got the check." And we were just like having a social call. That's fine. Like, socializing with the judge is fine. And I was like, "I got the check." And the judge is like, "No, you effing don't. F you, you do not have the check. We are getting separate checks because there will be no such issues." And I will tell you, the judge was right on that one. Like 100%. That was the right call. I was an idiot for saying, "Hey, I got the check." Like, that was just me being young and stupid.
That's the honor to pick up the check.
I mean, that actually would have been fine So, yeah. After receiving the counsel's inquiry, respondent denied that any attorneys were being forced and stated there were picked photographs of both male and female attorneys hanging in my bailiff's office that she took. Those photographs are provided. They provided pictures of two female attorneys, Kelly Howell and Jerry Neighbors, which were taken with the bailiff's cell phone on April 13th, 2023, in the afternoon after respondent received the
after they
complaint
received the complaint.
and falsely submitted to the council as though the pictures existed all along. The bailiff stated, the judge got the complaint. I called her office, said that Tracy needed them, and I took the pictures without the judge knowing, trying to protect the judge because the pink chairs were
I think at this
fault.
point I'm more weirded out by this than I was about the whole murder trial thing, which I'm not sure what this is about me or anything else, but damn.
The pink chairs is weird. I'm gonna say I tried to generate like a thumbnail that had a female judge in a pink chair, but the instant I told Midjourney female judge pink chair, it put the judge in like a pink dress, and I was like, "Damn it! I want the female judge in the pink chair, but I want the judge to look like a judge and the chair to be pink." So yeah. The two female attorneys came with another attorney at the firm, Hannah Bullock, and all three testified that the bailiff called around lunchtime and said, the judge needs you, but gave no additional information. When they arrived, respondent was on the bench, and while waiting for the judge, the bailiff offered to take their picture. So the bailiff is like, get here now, I need pics. And once again, if this was a male judge calling up female lawyers being like, get here now.
Yeah, that'd be pretty weird. Why do you want to have pictures of just female attorneys?
Yeah.
Is this for a trading card set or what? Okay.
So she says that she didn't know.
That's a funny idea, though. Judges passing around trading cards of attorneys. I like that idea. That's quite cute.
That is actually a funny idea.
I got two runkles for a Rob.
Bad deal, man. So she says that she didn't know that they were being photographed for this thing, and she didn't know that they were being fabricated. However, despite testifying to the council that the false statements and evidence she submitted were attributable to her bailiff, the respondent has not terminated her bailiff as an employee for not only allegedly lying to her, but also allegedly causing her to submit false evidence to an investigative body.
Yep.
I can tell you, if you are my employee,
the lying will damn you. You know, the falsehoods they'll screw you up, man.
If you're my employee and I find out that you have caused me to submit false information to a court, I'm going to come back to the office. I am going to be a flowing white mane of rage, and it's going to be get the out and leave an address, like email us with an address where I can send your box of crap. And I am walking you to the door with you now have a trespassing warning. Do not step foot on our premises for any reason, including if you have been charged with a crime. We will mail you your crap in a box. We may or may not shake it, depending on how angry I am when I'm done packing your shit up.
Yeah.
There is no way I would ever freaking tolerate that. And I can say the assistants I've had have been excellent. And one of them, fantastic guy, Devin, if you are watching this, you are a gentleman and a scholar. And he has helped me by being like, hey, the client dropped this off and it looks sketchy as hell. You should really take a second look at this document because I think it's full of crap. That's a good assistant. Right? That is when you've got somebody where it's, where he's like, hey, I got this document. I think it's bullshit. You might not want to submit it to the court. If he had, If he instead had been like, you should totally submit this, I would be upset.
Well, yeah.
If he's not watching, then he's still a gentleman and a scholar, but also probably can't send a super chat. So, so decorum and manifestations of bias. It keeps getting worse, by the way.
How?
It keeps getting worse. So, state of Oklahoma sought to increase the bond for defendant Jason Womack because additional counts of lewd acts with a child were added to his preliminary hearing. And he was also charged in another county with lewd acts with a child and was arrested in Kansas. Sounds like a real winner. The defendant's girlfriend, Miss Argo, was present during the hearing to testify, but was never called. While waiting for a deputy to arrive to remand Womack to jail, respondent addressed the girlfriend without prompting by saying, Ms. Argo, I don't know how long that you and Mr. Womack have been dating, but you might want to reconsider your life choices in this case.
Now, I don't know how we're faulting the judge for this. This just sounds like really good advice.
Because she's a witness. Because she's been flagged as a witness. Now you're tainting the witness. I mean, I agree. This is good life advice. As the judge, you cannot say this to somebody who's been flagged as a witness on the file.
Okay.
Ms. Argo responded with, I've read the preliminary hearing, Your Honor, and the respondent snapped back, I'm sorry? And so the defense attorney had to step in and tell respondent that he'd advised the witness to remain silent. She's picking a fight with the witness. Like, they gonna fight. Yeah. So then later they're going to dismiss the original charge of lewd or indecent acts to a child under 16 in exchange for a new charge of 3 counts of child abuse with the defendant sentenced to 1 week in the county jail and a 5-year suspended sentence.
Is this the part where I comment on how does that make sense? Please make it make sense. 3 counts of child abuse and we get 1 week in jail. Often 1 week for 3 counts of child abuse.
Often this makes
1
sense
week
when you've got a real weak case. I had a judge at one point who, so we were going through to enter a guilty plea to a much lesser charge than the original charge. And the judge was like, I don't like this at all. And the prosecution was like, candidly, if you don't accept this plea, we don't know if we can take this to trial. Like, the client was willing to plead to time served, and the judge was like, I don't think that's just, like, I think he should be getting a lot more time. And the prosecution is just like, we are accepting this deal because we have a shit case. It happens, right? You get witnesses who recant, you get evidence that you thought was going to be great, but turns out not to be. It happens. So I don't know. That's one of the problems with like trying to intrude into a plea deal is you don't know the basis for the plea deal. Sometimes the plea deal is based on all sorts of things that you just may not have access to.
I don't know at this point. I don't know. I can't say what I do for sure. But if my options really at the judge are like option A, take the plea deal with the 3 counts of child abuse, the guy gets 1 week in jail with a 5-year suspended sentence, or option B, reject it. The prosecution can't bring the case and the whole thing falls apart. I'm actually thinking about it because I'm so pissed that it's like I'm not going to endorse this. You know, no matter what. You know, this is your problem, prosecution, for not having for being pieces of shit. I'm not endorsing your bullshit.
And the other thing is sometimes the facts at the end of it end up being that things are much less serious than you think.
If that's the case, then fair enough. If that's truly what's going on, then sure. But if it's, you know, I was forced, if it's, you know, accept this shitty plea deal or the defendant goes free, I'm like, well, I'm not endorsing your bullshit. So that sounds like a not my problem. So plea refused.
I mean,
you know, file your no pros motion and get the hell out of my courtroom.
I had a case where a guy was charged with possession of cheese pizza. Some like 5,000 images. And
see, that's a lot. That's a lot of cheese pizza.
It is.
That is a lot of cheese pizza.
But the prosecution was like, hey, we'll do a plea deal for a breach of his probation by possessing a computer. He wasn't supposed to have a computer at all because of prior convictions. And the problem is that on review of all of these pictures, the prosecution was like, I don't think we can actually establish that any of these are cheese pizza. Instead, we can establish that these are pictures like from like catalogs and so forth that are creepy,
but not cheese pizza.
Not cheese pizza.
Like, so you don't have your prima facie case. Then fine. Yeah. Then dismiss the counts because you can't make your case. Fine.
And that's the thing, is the judge was super pissed about like, hey, why are we doing all of, why, like, you're dismissing all of these counts? And it's like, and the prosecution's like, we're dismissing the counts because we don't have a case on them. Like, we will lose. And the judge was still pissed. The judge was like, well, I don't like this deal at all. And it was like, so the prosecution is like, well, we'll agree to go give the pictures another look over to see if we can find anything to prosecute, which was ultimately just like, we will get this in front of another judge, because putting it over a week to do another plea, new judge, and the new judge is like, all right, makes sense. You're getting sentenced for possession of the computer, and the rest of it, yeah.
Fine.
Yep.
Keep your creepy catalog photos, I guess.
I don't think they gave him the computer back, so all of those were lost.
Yeah, that's very sad.
So on the date of the hearing, victims failed to appear. And after accepting the plea agreement, respondent stated, if I could force the district attorney to take this case to trial, I would not be giving you such a light sentence. And she also then later told everybody that the minimum required community service hours is 100 hours. This is like wide-scale prejudgment, because there's plenty of cases where somebody might require community service or might agree to community service, but the appropriate amount is less. Let's say I throw a rock at a store and I break their window. And as soon as their window's broken, I go up and I'm like, hey, I feel really bad. I threw the rock. I meant to throw the rock. I meant to break your window. But once it broke, I feel like a piece of crap. So I intentionally broke your window. I did it on purpose. But let's get a glass guy in, and I'll pay the repairs. And so, like, the glass guy comes in same day. I pay the rush fee. I pay all of this. They get a new window at my expense. I have still committed a crime, right? That's still a crime, even though you made it right. But the making it right afterwards is huge on sentencing, right?
Mm-hmm.
And so if I'm the judge, I might be like, listen, I want you to do 5 hours of community service, and then we'll call it good. I mean, honestly, I might just be like, you know what? I'm just going to say don't do it again, and your punishment is go away. But, let's say I feel like I have to impose some community service.
Well, I'm a lot more amenable to that in your hypothetical than with the 3 possessions of the child abuse.
Yeah.
Those are 2 different universes.
But I mean, she's still.
I did the 3 counts of child abuse, but I felt bad about it right away, and I made him whole. How about 5 hours even? Apparently, a week in prison was the right answer.
But following the court's acceptance, the plea in the state v. Kempf, one of the victims published a Facebook post stating her disagreement with the plea and the judge's sentence. The judge's bailiff provided a copy of the Facebook post to the respondent. That's not appropriate. The judge should not be doing their own investigations. They should not be looking at anything other than what's filed to them in court. So respondent then told an employee in the courthouse the state lied to her This was the second time they've lied to her, and it's 2 strikes and you're out. Although the plea deal did not include community service, she further advised the defendant that she requires a minimum of 100 hours of community service with all plea agreements, and was adding that to his sentence to be completed within 6 months. And I'm going to say 100 hours is a lot, right? Like, it's easy to throw out numbers. It's a lot harder when you're actually doing it, right? So I'm just doing some 100 divided by 8 is 12 and a half. So that's 12 and a half full days. So assuming you're doing one of those a week, like each week you work for your full Saturday doing community service. You know, on Sunday you're going to church or whatever else, or you're just, you know, whatever else. It's going to take you 13 weeks to do that. That's a lot of work, right? And like, what's minimum wage where you are, Kurt?
7 something an hour, I think. 7.50 an hour.
Let's look up what minimum wage is in Oklahoma.
Is it $7.25 an hour for minimum wage in the U.S.?
$7.25 in Oklahoma.
There you go.
So, you know, that's $725. I can tell you, I would rather personally pay the money than do the community service. So, but yeah, assuming that they build it at minimum wage. If they build it at my actual hourly,
Yeah.
Maybe not as much. Like if they build it at my hourly rate for 100 community service hours, that's a lot of monies. Let's not sentence Runkle to that. That would not be good. So, all right. They said during a conversation with the respondent in her chambers, District Attorney Panter asked her about the Kempf case. She stated, "Your district attorney lied to me and we'll discuss that on the record." A hearing was held on the record on April 25th, 2023, but defense counsel was not given notice of the hearing, even though the defendant was given a suspended sentence, and any revocation would be heard by the respondent. This is critical. If this guy F's up on his suspended sentence, because he's going to be on conditions, then she hears it. So he needs to know all of this. And, you know, defense counsel needs to be aware of this, of like what there's really good reasons why the court doesn't typically permit out of court discussion. And this is wildly inappropriate. On the record, respondent accused the district attorney's office of lying to her because the victim posted on Facebook that she did not agree to the plea deal. Respondent then stated she was filing a bar complaint against Ms. Thompson for the Oklahoma Bar Association to investigate the issue. To date, respondent has not filed a bar complaint with the Oklahoma Bar Association against Ms. Thompson or any other member of the district attorney's office. And the thing is that victims don't necessarily have to agree to a plea deal. At least not where I am. I don't know about it. I mean, maybe it's different in Oklahoma, but not typically.
No. No, even every victim's bill of rights I'm aware of at best requires the victims be informed of any plea deal, so they might be able to potentially lodge objections, but it does not require their agreement.
And there's really good reasons why we don't require the victim's agreement. And one of the reasons is that sometimes victims are crazy town. And sometimes the victims aren't actually victims. I had a SA case that the Crown dismissed. They were just like, we're not proceeding any further. The complainant on that one, and complainant is the preferred language in Canada instead of victim, because it doesn't imply that the crime happened. The complainant had a friend go to the police and provide extensive details about how the complainant had been planning to lie in court and had talked extensively with her friend about this. And the police investigated and were like, we think this is actually super credible. And so essentially the complainant was acting out of malice They weren't saying, hey, this actually happened. They were saying, I want to screw this guy over. I want revenge against this guy. And that was the whole point. No kidding, this complainant does not get a veto over the prosecutor withdrawing the charges. Because this complainant was a lying sack of crap. And that was, that was the end of it. It was just like, we have no hope of proceeding because obviously this person is full of it. So, yeah, and this happens for everything. Like every kind of crime, you will get people who are wrong, people who are malicious, people who are straight up crazy. Because I've had somebody at trial end up testifying, oh yeah, the reason why I'm so sure it's this guy is because the angels told me so. And the prosecutor, doing their job as a prosecutor, said, tell me more about the angels. They said, oh yes, I talk to angels all the time and they tell me things. They tell me what to do and what not to do. And they told me that this is the person who did the crime. And they're like, okay, can you tell me more about these angels? And it was clear, schizophrenic as hell, right? This was clearly some like paranoid schizophrenia issues going on. And so they're like, thank you for coming out here. That's all we need from you. Thank you. Defense counsel may want to cross-examine you, but just go out in the hallway. We'll decide if we need you any further. The witness gets up, leaves, and the prosecution is like, defense counsel is not going to need to cross-examine. Prosecution is asking that this case be dismissed. We're calling no further evidence, and we're inviting dismissal. The judge is like, granted. It happens, right? You get straight up crazy people. And I mean, that's not as an insult. It's just that, like, if the basis for thinking that a person committed the crime is schizophrenia, that's an issue. Now, that doesn't mean that a schizophrenic can't have actually seen a crime. Like, that also happens. But in this case, it was just like, no, I know because the angels told me. Oh, did you see the offense? No, I didn't see it. The angels just told me. I'm like, whew.
Do you know where we can find the angels? Because if they're the primary witnesses, we'd like to really talk to them.
Yeah, it was like, that's just one of those moments.
If we call the angels to the stand, that'd be great.
It's just like, all right. And like, I will give the prosecutor all of the credit on that one, because as soon as the prosecutor spotted the issue, the prosecutor started doing my job and basically was like, I want to know more about whether my witness is a problem. And once they determined that their witness was a problem, they're like, we don't want this case to proceed. This is an issue. Like, we're done here. And I'm like, that is how the system is supposed to work. That is the system functioning great. But it doesn't always happen. Now, the respondent attempted to mislead the counsel in testifying to the contrary. Respondent testified that the bailiff did not provide her the comments after the Facebook post, that she'd not seen the comments, and that she did not ask the bailiff to provide them to her. Pro tip: lying to the disciplinary board is a bad move. Bad move. So, they now have a case for the defendant to enter an agreed plea of not guilty by reason of mental illness on various felony charges relating to a fatal auto accident. Victim's family was present in the courtroom and asked Kelly Trimble, the ADA, to read a victim impact statement of the court. Respondent cited a journal entry finding the defendant not guilty by reason of mental illness, which provided the defendant would present to the Oklahoma Forensic Center for an examination to determine whether the defendant is presently mentally ill and a danger to public peace or safety. This is one of the common misconceptions about being found like not guilty by reason of mental illness. The insanity defense is people figure that it's just like, oh, you're insane, off you go.
Nope.
Instead, it's, oh, you're insane. Off you go to a mental hospital until that mental hospital is willing to sign off that you're not a danger.
Yep. And good luck.
Good luck, because you know how difficult it is to get a bureaucrat to sign something saying, I am putting my professional reputation on this person not criming.
Yeah. I've
Like,
actually seen cases before where a person was adjudicated mentally deficient and wound up serving significantly more time in the mental hospital than if they'd been found guilty in the first place. I
there was a
remember
case,
reading an article where the guy was been in prison for like 25 years and he would have only had to serve something like 8 if he'd been found guilty. And he still is no end in sight.
There was a case in Canada where a guy was shoplifting, was found not guilty by reason of mental illness, was held in custody for like 12 years, and was like, hey, why am I not getting out? I would have been out in like a month if I'd been convicted. And the court was like, yeah, you would have, but you weren't convicted. This isn't punishment. This is just mandatory treatment, and you're still not better. So you get to stay in potentially forever. Now, somebody was pointing out that the bus cannibal guy. Did you guys hear about this in the States?
I must have missed the bus cannibal note.
We had a guy who he's on a Greyhound bus, and he turns to this guy next to him in the seat who is asleep, and he murders the guy, beheads him, and eats part of the body. He's found not guilty by reason of mental disorder. He goes off to the mental hospital. He's since been released. And you know how many crimes he's committed since? 0. 0 crimes. Like, not a break and enter, not a theft under, not anything. He's just so
he stabbed and started eating a guy in the middle of a Greyhound bus.
I'm not talking about Luca Magnotta. I'm talking about Vince Lee. Yeah, he basically, like, he had some pretty florid delusions. The thing is that on his meds, he's able to be controlled on meds fairly easily. And they've got him on meds. He's still on meds. So people are saying he changed his name. Do not put his name in the chat. If you know his new name, I know his new name. Do not put it in the chat. I will yank you. Because, that's not appropriate here. But, yep. So, the journal entry further ordered the parties to appear back within 45 days for a hearing to ascertain whether there was a need for continued supervision based on the underlying exam. Multiple witnesses in the courtroom affirmed that it was obvious the parties were present for a plea and sentencing. She later vacated the order, or vacated the journal entry because it contains inaccurate statements and findings. She indicated to others following the hearing that the state lied to her in their presentation of the case because she did not understand when signing the journal entry that the defendant would not be punished. She thought she was sending the defendant to the forensic center to determine whether he could stand trial. That's inappropriate. Institute a policy that all plea paper must be completed with a copy delivered to her chambers no later than Friday before the Tuesday disposition docket. And the defense attorney said that it was a hardship for him to prepare and deliver out of custody plea paperwork on the Friday before the Tuesday disposition docket. And she said, it's not you I'm worried about, it's the DAs. They've given me reason in the past to not trust them. She also goes after this Melissa Missy Johnson, who's a coordinator. She says that she wants her gone. Yeah. Judge Mueller revoked a defendant's pretrial release bond because they violated the terms of the release. Respondent contacted the court clerk demanding to know who authorized the revocation, which would, of course, be Judge Mueller. So it just, and we're at page 23 of 47. It's getting late here. I can see you're yawning. This just keeps going with, like, you know, lies about issues, blaming
Joking
people.
about the signs of attorneys' penises. I saw that in the middle of the page. There it is.
Yep. So respondents' derogatory statements about and conduct towards the Lincoln County District Attorney and his staff have risen to such a level that her impartiality would reasonably be questioned in any case on which they appeared before her. Her conduct in this regard, to include telling multiple courthouse staff the ADAs have lied to her on multiple occasions, and thereafter threatening to file bar complaints against them based on ex parte communications she received, joking about the size of attorneys' penises during a trial, implying the state lied about missing evidence, and calling them a variety of names constitutes a violation of all the rules, but also constitutes gross partiality, as that term is used in the Constitution. Yeah.
Okay, so I see some problems here for the judge. I don't know what the right answer is here. I don't really have an opinion as the ultimate issue, but there does seem to be a lot here.
I kind of think that the right answer is yeet her into a fire. She also told people, many of the defendant's family, friends, and supporters were present in the courtroom that day. She said, but he's also in a biker gang that apparently likes to do some really ridiculous things that grown-ups really shouldn't really be doing. So that's a strike against him. But he's a member of a gang. Keep in mind, this is while there's a motion pending as to whether or not they could actually call this group a gang or not. So she's already kind of decided that. But he's a member of a gang, and that's a negative. I find the notion of motorcycle gangs and danger to the community in this kind of day and age to be ludicrous. And I'm talking to anyone in the audience that may be in one of these gangs. Be adults. This is ridiculous. Who in here is a member of the outlaw motorcycle gang? I have a very good memory. And if you come to the court and testify and testimony comes out that you are a member of the outlaw motorcycle gang or the pagan motorcycle gang, and you sat in my courtroom and didn't raise your hand, we're going to have a big problem. I'm remembering your faces.
Okay.
Like, that is wildly inappropriate. Like, hey, we're going to have a big problem in future court hearings if you don't do a thing now where you're not required to testify.
Yeah.
So she posted on a Facebook group to a girl called Girl Attorney OK. Note to future self, calling motorcycle gangs stupid and juvenile to a room full of gang members may get you on a hit list. And later responded to her own post, one of these days I'll learn to be judicial. That would have been a thing to learn before. Your expression on this is perfect.
Yeah. I mean, being a new judge, I can imagine you might have some difficulty, but not the most professional thing I've ever seen in my life. I imagine there's a learning curve to being a judge like anything else, but
so the defense attorney learns about this through both the members of the district attorney's office who say, we saw this and we feel we have an ethical obligation to tell you, as well as female lawyers at his own law firm. And he's like, wait a minute, despite the fact that you haven't held the hearing on whether or not this group can be called a gang or whether this guy can be referred to as a gang member, you've already made up your mind as to whether or not they're a gang. So he contacted the judge's chambers to schedule an in-camera meeting to ask that she disqualify herself. And the bailiff, who's playing a large role in this, by the way, demands to know why the judge is why he's seeking the judge's disqualification before agreeing to schedule the request. The judge, the bailiff calls and says, "Judge wants names. She wants to know where you
This
got
is
that
odd that
information from."
this is odd that this is the bailiff doing it. It would make more sense for it to be the judge's clerk than the bailiff.
I feel like the bailiff and this judge seem to have a friendship
Yeah.
that is, maybe a little too close. So, yeah.
I could see a judge's clerk making inquiries along these lines, but the bailiff making inquiries along these lines, very odd.
The bailiff says she wants all the names. All the names are required. After disconnecting the call with Banner to call the judge back with the names, the bailiff called Banner a second time to inform him the in-camera request would be taken up on April 10th at 9 a.m., that he should bring a written motion on the Rule 15 request, and that all previous orders in the case were stayed. Banner clarified that under Rule 15, future proceedings are stayed, to which bailiff replied, "No, all of her orders, including the bond, are stayed." Does that mean that his bail is revoked?
I don't know what that means.
Banner also concluded respondent had predetermined she would not grant the in-camera request based on her statement to the bailiff that he should bring a written motion with him on April 10th. Shortly after Mr. Banner contacted respondent's chambers, she posted on
and
the
you're going to
group-
put that in writing, by the way, of course, obviously. Like, you put the order in writing, like whatever it is, like all prior orders are stayed or all action, whatever it is. Like, you just don't put that. You can say it orally, but then you put it in writing on the docket, so there's a record.
So she says she's removing herself from the group because someone shared one of my posts outside this group. Apparently, this is not a safe place for a judge to be human. There is no safe place on Facebook. You are posting in writing for the public. Ugh, I got hiccups. Yeah, anything you put in writing, you should expect to see in a court proceeding.
Yeah, write your text messages like that might be read in court someday.
Yes, it absolutely is being. So they want to get an a court recorder for the in-camera proceeding. So they said, "We want a court reporter." The bailiff went to talk to the judge and told them, "Judge will not allow a court reporter in her chambers."
Why not?
Banner and Thompson both again said, "We want a court reporter." Banner and Thompson then hear a loud bellow from chambers, "No."
Why wouldn't you allow a court reporter in chambers? That doesn't make any sense.
Because she's doing some bullshit.
She's doing some shady shit.
Yeah.
I mean, if this is an on the record motion, then it probably, especially if they want. I mean, I could imagine there not being a court reporter necessarily there for an in-camera meeting. I could imagine that being, sometimes they can be informal. But if you want this on the record and you want the court reporter there on the record, then okay, do it on the record.
Well, and that's what the lawyer tells her. You're not required to put it on the record, but when we request that it goes on the record, that means you're required to put it on record.
Yeah.
And so she refuses again, and they say, "Okay, we want to go into the courtroom to make a record about you not allowing us to make a record." And so she rolls her eyes and says, "Okay, go in my courtroom."
Are you serious? Yes, we really are.
Yeah. So respondent was asked if she believed only one party was requesting a court reporter or both parties. Respondent answered as follows. 1, at the time that I originally said no, Ms. Thompson was standing at my door, not at my door, but at my bailiff's in the hallways. And she's not yelling at me angrily, but she's away from me. She's like, "We want a record." And I'm like, "You want a record?" "No, not in my chambers, not in my chambers." So you sought advice from other judges before you were aware that both sides, because at one point you did become aware that both sides wanted a court reporter. Isn't that accurate? Am I remembering that correctly? I went into the courtroom and made the record of me not allowing the record. And the thing is if she becomes aware that both sides want a record, there's nothing to stop her from saying, "I goofed. You know what? We're going to do a record." So, however, during the 15-minute break, both parties found Title 20, Section 106.4 of the Oklahoma statutes, which requires a court reporter transcribe a judicial proceeding upon request by any party. Now, you might be saying, why didn't the lawyers know this? And I can tell you that the reason why is because this is probably something they took as a given. There's plenty of things that we take just as a given, and we know there's a rule for it somewhere. But when you're actually called to like justify the rule, you're like, where the hell is that? Right? Think of your local town, right? You're driving along and you see a sign that says speed limit 100 or whatever. And you're like, okay, but what actually gives that sign authority? What law is there?
That's a good question. What lawful law?
What lawful? And the thing is, there is one. You just might have to dig it up, right? And that's really what they're looking at here, is they got to dig this up. In written response to the counsel, respondent stated that she inquired of Judge Bankman if she was required to allow the attorneys to have a court reporter during the in-chambers hearing. He advised that no, he would not do it on the record and to keep it short. And later, under oath at the hearing before the Council on Judicial Complaints, respondent again testified that Judge Bankman told her that's not how that worked and that's not allowed. Judge Bankman admits that respondent could contact him about this issue, but denies giving that advice, and further testified that he would not give that advice because he does not believe that it's in accordance with the law. She came to me, and that's not what I said. Also asked Judge Kirk. Judge Kirk says he advised to allow a court reporter and to be consistent between the in-camera and the courtroom requests. Before hearing the in-camera request, she told Judge Kirk she was going to deny the request. So, in response to his arguments about perceived and actual displays of bias, she said, I'm human. I'm entitled to have an opinion of the things that go on in the world. Every judge on the bench is entitled to an opinion about the things that go on in the world. So she didn't think that met the standard for disqualification, including whether impartiality might reasonably be questioned. And he then files a formal motion seeking her disqualification, and that was denied.
That's sort of the ultimate catch-22 of motions to disqualify. The judge that would grant the motion is the judge you don't need to grant the motion. You know, the judge is open-minded enough to be like, yeah, geez, maybe I should disqualify myself. Probably the judge you wanted in the first place. So there's a bit of a problem there.
I have had judges actively, like preemptively disqualify themselves.
Sure.
So I had a case where the judge is like, I've represented this particular accused like 10 or 15 times. I know too much. I can't hear the case. I'm declaring a mistrial. You need to get a new trial date. There you go. That was a good one. I've also had a judge where I said, I think there's like, I've got to ask that you disqualify yourself. There's a reasonable apprehension of bias. And the judge is like, I don't agree that I am biased, but I agree that a neutral observer could draw that conclusion. He's like, I don't think it's a correct conclusion, but I'm going to step aside. I'm going to get a new judge in here. And we got a new judge.
All right.
It was perfectly fine. So she's testified that she recognized that this was inappropriate, but she still refused to disqualify. She said, I agreed today, and I agreed on March 27th when Mr. Roberts' attorney, Mr. Banner, called my office to say that he was requesting that I recused. Yes, today I agree it's an inappropriate statement, and I agreed back then too. I didn't recuse at that point because I felt, again, in court, and Mr. Banner had stated to me at times I was appropriate to him and his client, and I didn't feel like I was biased against Mr. Roberts. Yeah. So this just keeps going, right? Prohibited extrajudicial activities, which includes posting on Facebook. Respondent published to Facebook a blooper of the day. Defendant on motion to revoke. I test positive for marijuana, but I have my card. Clueless judge. Is that even allowed? DA and defense counsel in unison. No, it is not. My bailiff laughing hysterically. I need to read the marijuana laws. Only 47 days before publishing this post, respondent had received training uh, admonishing against this kind of activity. Published to Facebook, filled in for another judge, and did my first domestic docket today. Finally, a subject I completely understand and can't possibly screw up. The counsel interpreted this to mean she agreed or believed that she'd screwed up other cases. That's not a good thing to publish.
Sweet.
Motion for default judgment on behalf of Tinker Federal Credit Union against the unknown successors of a deceased debtor. Respondent denied the motion on the basis that notice and service by publication was improper without prior approval from the court. The attorney noted that he'd been doing it for 41 years and had never done it that way. That same day, respondent posted on Girl Attorney Oklahoma Facebook group, "What not to say to the judge? I've been doing this for 41 years and have never done it that way. Definitely not a good idea, especially when you've been doing it wrong."
Okay, I'll just simply note here, counselor, or Your Honor, rather, since you've been a judge since January of this year, and this guy apparently has been an attorney for 41 years, might want to double check yourself on that one before you wreck yourself. Not saying an attorney who's doing it 41 years can't make a mistake, but you might want to, like, it's like, I've never done it this way before. This seems odd to me. It would be the kind of thing that maybe should catch your attention.
And he was unaware that she was making fun of his argument on a public forum with female attorneys, and that other attorneys have been made aware of the post. And she also solicited funds, which is a big no-no, for the Chandler Bell Cow Boil and the Girl Scouts.
What the hell is it?
I know what the cow boil is.
Yeah, I know what a crawfish boil is, but what is a cow boil? Are we going to get a bunch of cows and throw them into a huge pot?
It is a crawfish festival. I don't know why it's... And it actually, looking at it on Facebook, it looks really awesome. I would love to go to this.
I guess the guy's name must be Chandler Bell Cow. That must be the guy's name. Yeah, it's named after Chandler Bell Cow, Mr. Cow, I guess.
Or it's the Chandler area of Chamber of Commerce, and then Bell Cow must be the person's name.
Okay. Mr. Cow's crawfish boil. Oh, okay. Fine.
I mean, I actually think that this looks like a great time. Looking at it, it's a crawfish boil. I've always wanted to go to one, but
I have done a crawfish boil. I've done them at my house or my brother's house. They're fun. They're great. They're great for parties.
So, yeah. So, although involvement in the community is a noble effort, soliciting funds is a particularly problematic endeavor with very strict limitations about which respondent was specifically warned at the Judicial College. I feel like this is the least of her problems at this point. So, responsibility to decide. All felony probable cause for warrants and arrest must be brought to her. So that's weird. Respondent is otherwise the only district judge assigned to hear the felony criminal docket, which will create conflicts if the same judge both issues the probable cause affidavit and hears the proceedings following the preliminary hearing. So she thought the charges were too harsh because the defendant was a juvenile when the charges were committed, and now he's an adult being charged as an adult. And she was provided case law on the issue. She was told she need only be concerned about whether probable cause exists because the other issues will be handled at the appropriate time. She said that she felt that the young adult was remorseful and has turned his life around. She refused to either sign or return the probable cause affidavit for over 6 months. So basically, she didn't make a decision that she's supposed to make. Misapplication of Sixth Amendment and state conduct. Which is the Sixth Amendment? It's not quartering of soldiers. That's the third. It's not guns. That's the second. It's not speech. That's the first.
Yeah.
What is the sixth again?
Why can I not come up with it on the top of my head? Right to an attorney. Yeah.
I'm just trying to pull it up. Notice and nature of the accusations against them. So it's the confrontation clause.
Right to a speedy trial.
So in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of
And
the state
assistance
and
of counsel.
district.
So I was partially right. I just remember the last clause. Assistance of counsel is the last one.
Yeah.
Partial credit for uncivil. It's too late. I'm too tired.
Oh, it is getting late. We'll wrap up shortly. So, what was it? Rule 8 hearings, not defendants attempting to exercise their Sixth Amendment right to court-appointed counsel. She said she would suggest the defendants sell an asset to hire an attorney, but not order it. So, did the attorney maintain any client funds that could be returned to the defendant? You're on bond, and so you do not qualify for an indigent defense attorney at this point in time. If you wish to qualify for indigent defense, show up and you'll be placed back in custody where you will qualify. That's weird. She said it was not her practice to grant somebody who's out on bond on a state-appointed attorney. She said, if you're out, you're capable of working and hiring an attorney. Respondent added that if she was out on bond, then she was capable of coming up with money to get out of jail. It's often a lot cheaper to get out of jail than it is to hire a lawyer. So she's telling people that if they bond out, they won't qualify for an indigent defense attorney. So, recognizing that this was her first month on the bench, they sought a response from the respondent about what it perceived to be violations of the Sixth Amendment rights. You seem to be effing this up. Can we talk about this? And maybe could you stop fucking this up a little bit, please? So they expected that she would recognize the explicit requirements of making determinations on applications for court-appointed counsel based on the citations provided by the counsel, and noting that posting bond cannot be the sole factor in making this determination. And so she responded that the practice of not appointing court-appointed counsel to a litigant out on bond is not uncommon in many counties and courtrooms in the state.
I understand her logic in the first instance, right? It's like, because it's for indigent defendants. And it's like, so you can't afford an attorney. So if you're bonding out, I'm presuming this is cash bail, right? If you're bonding out, then it may suggest that you can afford an attorney, because where's this money coming from? So I certainly understand the problem. I get it.
The thing is if you've got a bail bondsman, you may not actually have the money.
Yeah.
Because bail bondsmen will take 10%.
10% is pretty typical.
And then they keep that money. You don't get it back.
That is the bummer part. They keep the money.
So, you've got a $10,000 bond. You put up,
$1,000.
$1,000. They keep that $1,000. That's not available for you to defend yourself. And that $1,000 might have been all the money you have in the world. Right?
Yeah.
So, and people say, but the bond is eventually recovered. If it's a bail bondsman putting it up, then that bond is recovered and it goes back to the bail bondsman.
No. Yeah, that's the deal. If you pay cash, then sure. Yeah, you'll get the money back at the end of the bond. But if you use a bail bondsman, no, you pay a 10% fee or 8%, 12%. Your mileage may vary, but you pay that money to the bail bondsman. They put the rest of the money up. You never get that 10% back ever. That's their fee.
It's
That's-
basically a really shitty short-term loan. And it's a short-term loan backed by violence, which is great.
Yeah.
Like, this is also why bail bondsmen are illegal in Canada. So we have a lot more no cash bails as a result.
And bail bondsmen then get all this wonderful power that they get to do their dog the bunny honey routine, because you're now technically in the custody of the bounty hunter, which means they get to kick in your door and drag your ass out wherever you can be found, blah 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 blah. See dog the bunny hunter for further details.
I mean, as much as that sounds like fun, I can see some good social reasons why you don't want people doing that shit. Independent investigations of facts and ex parte communications, because of course they're going to hit everything that they can. So without opposing counsel or the defendant present, the state and respondent continued to converse with the jury. Respondent explained to the jury that defendant entered a blind plea and what that means. After asking the jury whether they have any questions, respondent argued, obviously we didn't hear the defense side of it, but show of hands, who is leaning towards guilty? At this point, sentencing had not occurred and would be heard by respondent at a later date. After one juror did not raise his hand, respondent inquired, Mr. Colson, you didn't raise your hand. After which bailiff Angela Miller chimes in, I told you, he was the one I was concerned about. Respondent went on to advise the jurors, so I'll tell you, there's a videotape where she made statements consistent with the testimony of the daughter. To which a juror responds, that's what I was waiting on. Following her ex parte communication with the jury, but prior to sentencing, respondent told Judge Mueller it was not a good idea for the defendant to blind plea to her, and she was going to throw the book at her. I'll look at everything, but it's not going to go well for her. That is also not a good thing to say, right? Hey, I'm going to throw the book at this person. You've got to actually wait until you've heard the sentencing submissions before you make that decision.
It depends on your temperament as a judge. They do call them, there's this whole idea of hanging judges. Basically, just reflexively, will give you the max or as close as they can find to it. It's a style.
I don't think it's appropriate to prejudge. And I don't like hanging judges. I don't like judges that do the opposite, where everything gets a soft, super soft touch, right?
Judge Mueller is definitely giving you more than the week in jail for the 3 child abuse cases. So I'm just saying, if I ever become a judge, yeah,
at
it's gonna be more than a
sentencing,
week.
respondent suggested to the defendant that exercising your constitutional right to a trial was an enhancing factor in the judge's determination.
Ooh, no, you can't say that. Don't ever say that. No, that's no, that's wrong. No, don't ever say that. No.
Yeah. You cannot enhance a sentence for exercising a constitutional right. Yeah, it's just nuts. So sentence the defendant to 30 years on the 2 counts of lewd acts with a child and 40 years on the 1 count of enabling child abuse, to run with the 3rd count to run consecutive to the 1st and 2nd counts. So a total of 70 years. After learning the court communicated with the jurors following the plea, the defense attorney filed a motion to withdraw the guilty plea. The motion was denied.
I'm not sure there's anything improper with the court communicating with the jurors following a plea.
The plea could still be struck. Let's say the judge says, I don't accept the plea.
Well,
I mean, I think it's improper here. Respondent's in-person testimony. Within the first 6 minutes of her testimony, respondent used the F word 3 times. So here's where we get to she can't be a YouTuber. Because you can't say fuck 3 times in the first 6 minutes, or your video will get demonetized.
she can learn the rules.
She can't, though. They've tried to teach her the rules, and she is bad at rules.
Maybe she can go to Rumble.
That's fair. Rumble doesn't care if you fuck around. So, I mean, the audience on Rumble is much smaller, but she could maybe go on Rumble. In all 3 instances, respondent was recounting a factual or her strong feelings when she learned the Council on Judicial Complaints had subpoenaed her personal cell phone. You've got my cell phone. What the fuck? Fuck you. During her testimony, she exhibited a pattern of offering misleading or false statements. And then they've got a list of witnesses.
Oof.
They're asking for an immediate temporary suspension, and they want discipline. Specifically, they want her removed as a judge with a disqualification to hold any judicial office in the state of Oklahoma. I'm going to follow this one because my money's on she's not going to be a judge no more at the end of this.
Probably
That is
not.
where my money lands. And here's the thing. There may be a whole bunch of people who are seeking to have their convictions thrown out. There might be a bunch of new trials because she is shady. And here's the other problem. Some of those new trials might be impossible. And if those new trials end up being impossible, then guess what happens? Somebody goes free. So as an example of an impossible trial is, let's say you've got somebody who's accused of, SA. They're accused of a sexual assault on somebody. And while they're in custody serving their sentence for this, the victim of that gets run over by a bus. It's unrelated. It's just one of those crappy things that happens. But they die. And then you end up with a situation where a new trial has to be ordered. Well, the victim isn't going to be able to show up. And so you might end up with a situation where the accused is acquitted because there's not a victim anymore. It happens. They might, I imagine the prosecution would try to get the testimony in through other means. But, yeah, the texting is the least of the problems here. The texting it's just the evidence on all the other stuff. So I think this one is fascinating.
I think so too. And I think it's like many of those things. It's like the accumulation of things. And that's basically so there's quite a few accumulation of things in such a short time, which is also kind of hilarious because she's only been on the bench since January. And she's managed to pull all this off in like 10 months. She's speed running, getting defrocked.
That is impressive.
It's like under a year, man. Lose your rope, baby. And try again, baby. You're better as an advocate, I guess. Damn. It's like the Chief Justice of the state doesn't want you around. Shit. Yeah.
That is impressive levels of speed running, getting removed. Whoop. And some people are asking for a picture. I found a picture.
The pink chairs is still throwing me, though. I'm not going to lie. The pink chairs thing is still throwing me quite a lot.
The pink chairs is weird.
Yeah.
So that's a picture of her. Kind of unremarkable, I think.
Is it odd that she's been a judge for less than a year and she's already hearing full-on murder trials?
It really depends on where you get posted. Like if you become a Crown prosecutor in Edmonton, by the end of your first year, you're probably still running like low complexity trials. If you are a Crown prosecutor in a rural jurisdiction, by the end of your first year, you've probably got a murder on your docket.
Sweet.
So, same thing with judges. I imagine that some of the judges, it's like, okay, well, you're in a busy courtroom. You've got, there's lots of other
figure
judges.
it out as we go, right? It's like, okay, well, I've been a judge for 6 months. I got a murder case. So it's like, well, I guess we'll figure this out together.
I have actually had a judge tell me that, like, this is my first firearm hearing. I guess we'll figure it out as we go. And I'm like, no. Like, we should know that.
At least the judge is willing to admit what they don't know. That's a start, right?
Yep. And to be fair, the judge was actually very good about things. I just had a groaning moment when they said that. Like, I've never done one of these, so we'll figure it out. And I'm like, no. Of course, it could be worse. I mean, you don't want the situations where they just don't know what they don't know. All right, I'm going to read super chats, and then I'm going to wrap up because it is late, and I am tired, and I haven't eaten all day. I should have eaten some things.
Well, before you get to the super chat, I'm going to pimp my channel for just a second.
Oh, absolutely.
I'm experimenting with a shift in format. So I posted a video today that was an edited and scripted video. It's like, I think it's only like my second scripted video I've ever done on my channel. I experimented with like a scripted video before, and I did a scripted edited video today. And so I'm also posting one on Wednesday where I think it's just going to be voiceover with suitable graphics and B-roll and stuff like that. I'm working on it.
Okay.
It's on the United Auto Workers Union strike. So I've already recorded the audio and I'm working on the video portion. But that should be posted on Wednesday. And then hopefully on Friday, I think I'm going to have one dealing with the Israeli conflict if I can get it done in time. But I'm trying these. Yeah, I'm trying these scripted, deeper, these scripted things. And so I'm changing formats. The one today did actually very well. It was like 40% more popular than my running average of videos. So hey, that's nice. That's
pretty good.
So yeah, it was #1 video of the last 10. It was like 40% higher than the running average. So we're heading in a good direction. So check out my channel and we'll see if all this wonderful expenditure I'm making for editors and such is worth it. So see what's going on over there on uncivil law.
Nice. So, yeah, check that out. That is a good thing to check out. And I guess let's go through super chats here. Yellow Pill 17 says it should be attention dysregulation, not deficit. I agree entirely. That's my feelings on that. Against the Tide says don't forget to like the stream. So don't forget. Rhineman YYC says new vocation in law, forensic necromancy. I feel like that would be required in like a D&D setting. Linda Santiago says, so glad I found this. It makes Mondays better. Mondays inherently have a lot of suck. And hopefully we can make them a little better. Creed M says, everything looks bigger in baby hands. That is a creepy comment. I can and I will. Stares at Spicy Draco. I think that's me. Or that might be from the Depp trial. I'm not sure which one. Talia E. Now people will wonder if he is really guilty and this was just a rigged trial. If innocent, it's tainted. If guilty, justice is miscarried. What a mess. Yep. Sad thing is, if she did this in favor of the state, she'd be judge of the year. Yeah. Is it Zachariah Anderson who's in custody right now? Moving on. Auction a brick wrapped like a fruitcake. Fair. Rhineman YYC says rock can also be served as food like brick. Fair. Rory O'Connor, apprehended bias, unethical conduct, and contempt by a judge, censure or dismissal. I think in this case, if the allegations are made out, they're at the point where dismissal is really the only remedy. I don't think this is like a, hey, we'll yell at you. So, Lori Lenny, does anything happen to cases she presided over? I'm sure there's going to be a whole lot of defense lawyers going, my client should be let go. Let my people go. Moses and Moses LLC. Emma Z, thank you for 5 gifted memberships. Much appreciated. The judge would have been an academic or limited practice. Maybe. That is possible. Consult your dear wife for food. Nice one. Take care. I've actually got food provided by my dear wife. It's not the best to eat. We've got Grant Horn being a bit of a jerk, saying uncivil looks like Quasimodo right now.
I'm not exactly sure what that means. Is that a good thing? Is that a bad thing?
That's probably not a good thing. That's
The troll thing?
That's from the Hunchback of Notre Dame.
Yes, I know what the reference is. I just didn't know how it particularly referred to me in this moment.
Can I join your Discord? Yeah, I can drop an invite link in the chat here.
I have read a book before. I do know who Quasimodo was.
I wasn't sure. People... I try not to assume because people, have different takes on that.
It's fine.
I'll drop a link. That's to the Role of Law Discord, but yeah. All right. So let's wrap things up here. I think that's all of them. So yeah, guys, check out Kurt on Uncivil Law. As mentioned, he's doing some new stuff, and yeah, that is. Oh, and somebody says Twitter DM'd a quick render regarding the judge with the pink chair. Oh God. Let's see what we're looking at here. That's not bad. I guess I'll pull that up because it is the judge in the pink chair. Although the resolution is not the greatest, let's pull that up here just because, hey. Where's that picture? Judge, pink chair. I'm curious about all of these. I'm curious about all of these, images. It was a Depp trial reference. Yes, I get who you're talking about now. People sometimes have accused me of being a Malfoy, so that's why I get confused on that one a little bit. All right, so thank you guys all for joining me. I am going to go eat some things and sleep. I don't get enough
sleep is good.
So we're gonna try that. I'm probably gonna fail, and that sucks because I have an early morning, but we're gonna try. So thank you guys all for joining me. Let's roll the outro and see you guys next time.
Bye.